Yes.
That one registration application.
Oh, and this minute order 41 application. Give.
My lord, for inclusion, mandamus appeal, my lord. Mandamus appeal group 2, my lord.
Appeal next week. Come.
My lord, application. Oh, next week.
Application give.
Your Lordship, may I be permitted to mention a matter? This is appearing as item number 76 in your Lordship's list. There is some urgency. Mr. Shuktinath
Where
Mukherjee is
you were
appearing.
yesterday?
No, sorry, Your Lordship.
Entire list was called yesterday. Where
Lordship,
you were?
There is some urgency, Your Lordship.
But you
Mr.
should
Shuktinath
come,
Mukherjee
you
is
should come.
appearing.
We have completed the entire application yesterday.
Your Lordship, it's under Order 41, Rule 11 for admission.
Oh, order 41 you will take up. Will take up.
Your Lordship, the list is the number in the list is 306. The petitioner is an armed force soldier, and he has been not being reinstated, despite the fact that Justice Partha Sarthi Banerjee sir has already, Chatterjee sir has passed the order for reinstatement in 28 August 2000.
There we'll see to it. Don't worry. We'll see to it.
So upgradation is
It's not. I have refused every member of the bar. Upgradation. We'll take up. Every litigant is equal, so we'll take up.
is unemployed, Your Lordship, for the last
There
10
are
years.
many who are really seeking an unemployed. There are
306.
just wait. We'll take up.
The matter, my lord, an application for inclusion, my lord.
Application you give.
Urgency, my lord, is the
No urgency give.
Your Lordship, the matter was first being heard by Mr. Honorable Justice Shobhashachi Bhattacharya. Thereafter, for admission, it has been brought to
Let
the
us
attention.
see. Let us. It has come before us. We will see to it.
My lord, I want to mention one matter, my lord.
Oh,
My lord, from Port Blair, my lord. My lord has taken one contempt matter, my lord. It was lastly fixed on 22nd of January 2024, my lord. There was 6 weeks time was there. Thereafter, the matter has to be put up, my lord. But thereafter, the matter was
we'll
not
see
put
to
up.
it. We'll see to it. Send the number.
My lord,
Sir will take care of that.
My lord,
my lord. Oblige, my lord.
an application under Order 41, Rule 11.
Application does not align. Anyhow, order 41 rule 11.
Oh, Order 41, Rule 11.
Yes, call the list.
Item number 2 means item number 1. In this matter, my lord, I am for the respondent writ petitioner.
Yes. What for?
My lord, we mentioned the matter, my lord. It was
appellant, my lord. We have not mentioned the matter, my lord.
my
They
lord,
have
we
served the
mentioned the
letter.
matter, my lord, CAB on 9 July.
We'll keep this matter again. No, it was not CAB because the apex court has
No, kindly see, my lord, 9 July order.
it. When we can fix again
Your lordship, as your lordship, my lord.
next Monday.
But Monday, my lord, I have some difficulty. Tuesday, my lord. But next Monday, my lord, I will not be there.
Tuesday আমার অসুবিধা আছে দাদা।
Monday তে আমি থাকবো না, এই হচ্ছে problem.
It is a recurring feature. Whenever the bench suggests a date, lawyers will always have a problem on that day. I have not come across a single instance where the bench has said on that date and the lawyers agreed. Never.
I have serious difficulties on Monday, my lord. Otherwise,
Thursday, next Thursday. Thursday week, not tomorrow, Thursday week.
Grateful, my lord.
yes, yes.
Grateful.
Let the matter be listed on Thursday week for further clarification.
Yes,
Grateful, my lord.
yes. Oblige, my lord.
Let's call the next. Order
Item
41.
number-
Order 41. Call. No. Order 41.
Item number 58 to 60, order 41.
May it please your lordships. My lord, these are my appeals, my lord, 3 appeals. 3 appeals have been necessitated, my lord, because the interim order which was passed against me kept getting extended. The interim order which was passed against me kept getting extended, which is why there are 3 separate appeals
Yes.
challenging subsequent orders of extension. Lordship has heard me in detail, my lord, this matter. My lord, this is the matter regarding, my lord, where the interim order was passed against me in a suit, my lord, which is barred by the provisions of the RERA Act. So the court has no jurisdiction. Order passed without jurisdiction is a nullity.
Shows the act.
Yes.
Your Honor, I'm appearing on behalf of the respondents. I'm being led by Mr. Ritobrito Mitro. My lord, kindly give a short pass over. He's just on his way.
41 he does not have. We have to hear. Call him.
Let me just give another copy, my lord.
Where is a
Section 79.
exclusive?
Section 79, my lord.
Yes, 79.
Yes, my lord.
And tell us that what is the nature of the dispute, and this comes within the peripheral of
Yes,
the adjudicating officer or the appellate tribunal.
my lord. Nature of the dispute, my lord. I had purchased a flat. Flat was supposed to be handed over to me in 2019 after keeping in mind a 1-year extension. Flat was not handed over to me, admittedly. I repeatedly asked for a completion certificate. No completion certificate was also handed over to me. In such circumstances, I was compelled to approach the RERA. I filed a complaint before the RERA authority, seeking possession and seeking compensation in terms of the statute. While the matter was proceeding before the RERA, my learned friend's client, being the promoter, they were aware of the RERA case. They appeared before the RERA authority as well. In the month of February 2024, they went and filed a suit before the Aleppo court and moved an application under Order 39.
What for?
Yes. So their grievance was, my lord, they essentially sought specific performance. Kindly, my lord, take their plaint of the agreement for sale.
Okay.
My lord, will see the plaint is at page 33 and the prayers are at page 47.
Page.
33 of my stay application of the first matter is where the plaint starts.
Yes.
And the prayers, my lord, are at
Agree.
page 47.
Balance amount.
Yes, they allege that there's a balance amount payable by me. My case is that there is no balance amount payable by me, but that goes into the merit. Ultimately, my lord, they want me to perform my obligation of payment.
Correct.
And therefore they seek specific performance.
Correct.
This prayer could have been agitated by them before.
Where is the power of the adjudicating
yes.
officer to grant a decree
Yes.
for specific performance?
My lord will kindly take section 31 of the Act.
31.
31, my lord.
Yes.
Filing of complaints with the authority or the adjudicating officer. Any
I have read it.
yes, your lordship had read it on the last occasion.
Any violation, contravention, rules and regulations against the promoter, allottee, or real estate agent, as the case may be. Yes.
Now kindly see, my lord, section 19.
19.
Subsections 6, 7, 10, and 11 in particular. I placed these on the last occasion also. Section 19, my lord, talks about the allottee's rights and duties.
Yes.
Kindly see subsection 6. Every allottee who has entered into an agreement for sale to take an apartment, plot, or building, as the case may be, under section 13, shall be responsible to make necessary payments in the manner and within the time as specified in the said agreement for sale, and shall pay at the
That's
proper
an obligation of an allottee.
allottee. That's right.
That's
Which
all.
according to them I have violated by not making payment.
Whatever. Then
7, my lord, it talks about the allottee's obligation to pay interest.
yes.
10, my lord, talks about the allottee's obligation to take physical possession of the property after the occupancy certificate is issued.
This is not according to you, they till date they have not.
At the point of time when I approached the RERA authority,
It was not.
admitted, according to me, they had not disclosed it. When they filed the Aleppo suit, now it has come to my knowledge, they have annexed a copy of an occupancy certificate, which they have obtained. And 11, my lord, talks about my participation towards registration of the conveyance deed.
Yes. What are the powers of the
Yes, my lord.
RERA?
My lord, the powers, my lord, are provided. Lordship had the occasion on the last occasion.
What are the powers?
Kindly, my lord, see, my lord, sections 35 onwards. (35, 36, 37, 38, 40). Very wide powers, my lord.
Bombay judgment.
Is there any rules or the regulations made?
Yes, yes.
Where is that?
That possibly is in that book. In my book, it is there. The West Bengal Real Estate Regulation and Development Rules of 2021. Rule 24, my lord, talks about additional powers of the authority.
Yes.
That I'm not addressing your lordship on the merits of the matter as such, because my point is limited, my lord, whether the honorable court had the jurisdiction or not. Order passed without jurisdiction is a nullity. I have judgments on that, but perhaps I need not show them. Just two dates I'll just point out, my lord, touching upon the merits very briefly, in case my learned friend were to raise them, my lord. They had offered me possession for fit-outs, but that was admittedly well before the occupancy certificate or the completion certificate was alleged to have been granted. So that, my lord, is not a proper handing over of possession or offer of possession. That was on 18 January 2023. And one letter I will show, my lord, which will show that admittedly they had not obtained the certificate of occupancy certificate on that date, and they had offered to pay me compensation as well. Kindly, my lord, take the letter at page 85. It's an email, my lord, of 26th May 2023, written by, my lord, Hari Sharma of the respondent company to my client, Deepak Mavandia. My lord, dear Mr. Mavandia, please refer to your mail dated so-and-so. You and Mohit are like my brothers too. The next paragraph is important, my lord. Please note that your captioned unit is ready since last year and a half. A letter reminding you to take possession for fit-outs was also issued to you on 27 January 2023. The unit has been completed strictly in accordance to the sale agreement executed between us. The process for obtaining the completion certificate from the KMC is in process and is expected soon. Kindly, my lord, also take, my lord, the penultimate paragraph or the second last paragraph of this email on this page. In view of our long-standing relationship, we will mutually discuss and amicably settle on the payment of the delayed charges during your visit to Kolkata.
Yes. That was on 26 May 2023. And the occupation certificate or completion certificate
Is, my lord, obtained on, can you give me a moment? Tell me the date. 17th July 2023, which is at page 77. They have formally never informed me of the same.
77, I can't read.
That is the copy, my lord, they gave us, my lord. We don't have a better copy than this. I'm sorry. This is annexed to the plaint. All that I can see on the top, my lord, Kolkata Municipal Corporation and completion certificate. And there's a date at the top, 17th July 2023 on the top right-hand corner. No possession has been offered to me since this date.
Where is the power to grant a specific performance decree?
A specific performance, my lord, in this case, the only obligation on me, my lord, two obligations, broadly speaking. One is to make payment, and the other is, my lord, to execute the conveyance deed.
Now, there are
Both-
two aspects. Kindly visualize the situation.
My lord.
One is, I have seen the purpose and the object of the RERA was that if there is any contravention at the behest of the promoter, allottee, or another person's, whatever,
My lord.
then in that event, he can approach the RERA, raising a grievance for the purpose of redressing those deficiencies and the compensation to be awarded. But so far as the decree for specific performance is concerned, I have a doubt, little doubts from the section 34 that whether those powers are retained with the RERA.
So far as specific performance is concerned, my lord, two obligations on me. One is to make payment, and the other is to sign and execute the conveyance deed.
Correct.
Both these obligations, my lord, are encompassed within the parameters of section 19 of the Act.
Does
In-
not appear to be so.
My lord, in terms of the obligations of the allottees.
That is what is a different, that's an obligation. There are two aspects.
My lord.
There is an obligation of the allottee or the promoter, whatever his obligations are there.
Yes.
There is another remedial parts and the powers. Suppose if this obligation is not honored,
My lord.
then in that event, to what extent the RERA authority can exercise their powers? The powers is the contravention, compensation, interest, penalty, whatever. That is what is that emanates from section 34. Nothing more than that. Now is a decree for specific performance. Whether that can be granted by the RERA is the sole question.
Absolutely, my lord.
It does not appear that they can exercise the power of a civil court in that sense, except to certain extent. They will exercise a power that of a civil court, summoning the witnesses,
Yes.
calling them.
All the
But it
procedural
does not-
powers.
It does not say that all the trappings of the court they will assume. It does not appear to be so. You will find under the Consumer Protection Act,
My lord.
the State Commission or the District Forum,
My lord.
similar powers are given in that statute also. And there has been a judgment on that score which says that no, they do not have an absolute trapping of a civil court. And there are certain things which the civil court can grant, which relates to a specific performance decree. Now, question is, suppose if the specific performance decree is passed, the only thing is that you are obliged to make the payments and then they execute the deed. That's all. But so far as their obligation for payment of the penalty, the compensation, that would remain upon them.
Yes, for which I'm pursuing my remedy before
No
the RERA.
difficulty. These are the two different facets which will run simultaneously. So you will get that. There is no
Yes,
difficulty.
yes.
You can proceed on that basis against them.
Yes.
So these are the two things which are absolutely independent.
One is
Infusion
violation of
very
his,
difficult.
one is violation of his obligations,
That is what is there. For
Which-
that he has to pay whatever.
for which I've
Understood.
approached the RERA and
Correct,
and
that
I'm
will
pursuing
take.
my remedy.
Correct.
Second is, if there has been any violation of my obligation,
This is
whether the
under
RERA is the
agreement.
appropriate authority or not.
No. Specific performance is the first and fundamental principles which the plaintiff has to say that he is ready and willing to perform his part of an obligation under the agreement.
Very good.
And he was all along ready and willing to perform.
Right.
So if they could satisfy that they were doing it, there is no difficulty in granting the specific performance degree. Now, after the amendment having been brought in Section 10, is no longer a discretion of the court. It is now is a mandatory. The moment he proves those ingredients of Section 16,
My lord.
the court is bound to give grant a
Absolutely.
decree. Now,
Absolutely.
compensation, you can get it back, no difficulty. If the RERA ultimately decides that they were under the obligations. Now, can you visualize the situation? There may be a multiple, the grievance that may come. He has given a particular specification in the agreement that he will provide. Say, for example, hypothetically, the Jaguar, the fittings. And it appears that the Jaguar fittings are not given and it is some other company's goods or the gadgets that has been placed. You may raise a grievance because under the agreement, you are obliged to provide a Jaguar. Similarly, if they say that they will provide this cabinet, if they do not provide a cabinet, if they say that they are obliged to give you this much of area, and it appears that there is a shortfall of an area. For that, you can definitely approach the RERA and you can have the compensation. But so far as the obligation under the agreement is concerned, I think that is a separate issue. That's a separate issue.
May I, my lord, put it slightly differently, my lord? So far as his obligations are concerned, my lord, I am not agitating before your lordships at all. Fittings, no fittings, cabinets,
No, that is what I'm saying.
Today, my lord, the limited focus of
Focus is whether the RERA has an unbridled power even to grant a specific performance decree.
Yes.
To us,
Absolutely.
apparently, as of now, I do not find
I will satisfy
that the RERA is conferred with those powers as well.
I will satisfy your lordships.
I do not find.
I will satisfy your lordship. Kindly give me 2-3 minutes. I'll try and satisfy your lordships.
So I express my mind what is
Yes,
playing in my mind.
I'm grateful for that. Today, your lordship is raising the issue of concern whether the RERA has the power to grant specific performance
That
or
is
not.
your argument.
Yes.
We are not raising. You are raising.
What is the implication, my lord, of specific performance in this particular case? The implication or the end result, if the court were to grant specific performance, was that I would be required to make certain payments which I have allegedly not paid and execute the deed of conveyance. These are the two implications.
No, I will not go into this aspect. I will go that though he was ready and willing to perform his part of an agreement or a contract,
My lord.
but you have not performing your part of the obligation,
Yes.
and therefore
Yes.
he has gone to seek for specific performance. That's true. Payment, no payment is a immaterial for that.
May I join issue? of that?
Payment and no payment is immaterial. They have gone for a payment,
Yes.
but I say is immaterial.
A specific performance of my obligation is all only with regard to payment.
That is in this case.
Yes.
But in a broader sense,
My lord.
the specific performance concept is different.
Yes. But in this case, my lord, I'm focusing only on this.
Suppose the entire payment is made,
My lord.
but you are not coming and signing the deed for execution.
They can go to the RERA.
They can go for specific performance, compelling you to.
They can go to the RERA also, my lord.
Oh,
That is my case.
That is what
Yes. Yes.
that is what is a big question mark, whether they can go to the RERA for that.
I'll convert that question mark into an exclamation mark, my lord.
Let us see. Or a tick mark.
Or a tick mark, my lord. Two obligations can only be there on my part. One is payment and one is signing the conveyance deed. Both are, my lord, captured under Section 19 as obligations of the allotment.
Section 19 does not speak of that.
My lord, kindly, my lord,
Those are the obligations.
yes.
These are, again, I'm saying.
Because there is a fail, let me assume that whatever they have said in their plaint is true and correct.
Then again, when you have come in a civil side, then I'm giving you a hypothetical example.
My lord.
Take the Transfer of Property Act.
My lord.
Look at Section 108.
My lord.
108 contained an exhaustive provision relating to rights, liabilities, and the obligation of the lessor, rights, liabilities, and the obligation of the lessees. These are the primarily liabilities of the lessor and the lessee. But Section 111 does not really talk about anything of that, which is really a remedial provision. So one is an obligation and another is the remedy.
Yes. I'll marry the two. I'll marry the two in this case.
I think it is not.
I bow down to that. And I'll show in the RERA, there is a marriage of the obligations and the remedies.
1 minute. 1 minute.
My lord, the obligations and the remedies are in conjunction with each other. On a failure of an obligation, there is a remedy provided under the statute. First, I will satisfy your lordships on the point of obligations. Section 19, subsection 6, my lord, talks about payments.
Allottee's
obligation to make payment. And similarly, my lord, there's an allottee's obligation also to register and execute the conveyance deed. So obligations are clear, my lord. And those are the obligations in terms of the agreement for sale or the contract between the parties. Now, my lord, section 31 talks about an aggrieved person. Naturally, my lord, the promoter will be an aggrieved person if I do not fulfill my obligations. He is aggrieved, which is why he's approached the civil court as well. He is claiming payments have not been made. So he is an aggrieved person. There cannot be any other way. And the section contemplates, all the sections contemplate, that a promoter can also approach the RERA. There's no difficulty on that point as well.
There is, can you bring a judgment of Mandira Mukherjee of this court? Division bench.
Try and get it, my lord. I also have judgments of various RERAs. I do not want to place them, but I have them.
Not RERAs.
No, I know.
Do you have that copy of the Mandira Mukherjee's? It just struck in my mind. Of Justice D.K. Seth, if I correctly remember. Find out that judgment. Why I tell you, what you are saying is in your support. You have not worked on your brief.
In this case, I haven't seen, I'll be candid.
And there is one judgment of the Supreme Court in this regard also, very small judgment. I'm just trying to recollect or remember that name. Just give me some seconds, I will give you that name. Unable to recollect. Have you got that Mandira Mukherjee?
No, let's just search for it. May I continue in the meanwhile? Or lordship wants to?
No, that is the answer to your argument.
Let me know, kind of.
That case originates from a Consumer Protection Act. There is the right of the consumer. Anybody who is aggrieved, he can approach the consumer forum. But it is like a similar provisions is like that. If there is a deficiency in service, then the question arose whether he can go for a specific performance before the consumer forum. In the Mandira Mukherjee says that it can. In consumer forum has a power to grant the order for specific performance in your favor.
Right. I'm grateful, my lord.
If you compare this Consumer Forum Act, Consumer Protection Act, and this act,
there are similarities.
More or less, there are similarities.
This, of course, has an exclusive jurisdiction.
There also, if the obligations were there was a deficiency in providing a service. That also comes within the peripheral of that consumer protection. So that was there, and compensation was the only remedy. Then the question arose whether specific performance order can be passed. The court held yes.
Right, one of the major distinctions between the Consumer Protection Act and the RERA is, of course, the bar of jurisdiction section, which is there, which is not there in the Consumer Protection Act.
This is this because of it's not in derogation. What it is not in. It is in addition to, but not in derogation with any other act.
Any-
I think section 3 or 4 of the Consumer Protection Act.
And there are various judgments on this point as to how parties can move parallelly.
I remember the name of that. Did you Mandira MANDIRA?
Let's not waste.
Lordship, once we can come back, find the judgment and come back. Mandira Mukherjee was Meera.
Mandira Mukherjee, I may be wrong, Mukherjee, but Mandira, I am sure.
Mandira Sahib,
On Consumer Protection Act.
the Consumer Protection Act, no? The Mandira,
Mandira Sahab, maybe.
the Mandira, Calcutta High Court Consumer Protection. This might be the one. Mandira Mukherjee versus District Consumer Disputes. Who's the judge? Justice D.K. Seth.
Mandira Shah.
No, Mandira Mukherjee only. Mandira Mukherjee versus District Consumer Disputes Redressal Commission.
This is what I
2004.
wanted. Look at that, open the judgment. Don't you have a head note there?
No, there's no head note. It's an India Kanun.
Well,
No, SCC online. Then the SCC online, we are having a look.
that also does not have a head note.
No, unless it's reported somewhere, it will not have a head.
CHN, reported, CHN,
CHN.
CLJ, everywhere.
Then we.
That I'm just reading, I've quickly glanced through it. It's a slightly lengthy judgment, but just towards the end of it, we hold that the Consumer Forum is competent and has jurisdiction to grant the relief of execution and registration of the conveyance in the kind of contract involved in the present case.
This is what I really wanted to say. This is in the nature of specific performance.
Yes. Present proceeding is maintainable before the Consumer Forum.
Look at in the same Consumer Protection Act, this power as of a civil court, the incidences A, B, C, D, E is also given the same
Similar.
one.
That there is, yes. That there is, that I'm aware of.
It's a division bench judgment.
I don't think so. I think Justice Seth only. Huh? What? Only Justice Seth.
Any reference of the Supreme Court judgment there?
There are some references to some Supreme Court judgments. No, but maybe it is a division bench. Maybe the judgment is authored by Justice Seth because it says the appeal is therefore dismissed.
Yes,
Order
a
passed by the
division
learned
bench.
single judge under appeal is hereby affirmed subject to observation. Possibly it's a division bench. The judgment is authored by Justice Seth. Because there can't be an appeal from a consumer protection.
Let me, my lord, have a look at this judgment, and if I have to deal with it, I'd like to, my lord, go through it and come back.
2004 or 5?
2004.
My memory is not that bad.
Bad.
I have a decent memory, but I remember only obscure things, irrelevant things. I wish I remembered judgments.
Read that.
I'll
I think, and I think there is one Supreme Court judgment on that score. 3-4 paragraphs that talks about this principle. So if you look at the Consumer Protection Act, you will not find any powers given to the district forum or the state commission to pass a decree because that is the civil court's jurisdiction.
Correct.
So question arose that whether they can. This was the last one. They can compel a party to execute it. The argument was advanced before the court that look, the powers of the consumer forum is very limited. Executory power,
It's not
I mean
vested.
execution. In a civil courts, the conveyance can be executed through the courts.
Correct.
If the parties
Correct.
deny or they do not implement that decree or they do not honor that. Whether the consumer forum has the same powers, if the party they do not come, then whether the consumer forum can appoint any persons or through somebody the registration and the division bench head, yes, it can because of the various powers. I also find so far as the implementation of the orders, there is a provision. It's a wide one. It does not talk about Order 21. Had it been that it will be regarded as a decree under the Civil Code of Civil Procedure and executable as such, then it really roped Order 21 into it. But this is a wide power. It's a wide power. So that is what I was just thinking about it, that what can be done, because there are provisions which says here implementations.
Section 40, my lord, enforcement of order.
Yes, this is no, yes. If the promoter allottee, as the case may be, fails to pay any interest compensation imposed by him by the adjudicating officer, as the case may be under this Act, rules, regulations, it shall be recoverable from the promoter. And then B2 is if any adjudicating officer is such as they issue any order or direction, any person to do an act. This is what I say, this execute or do it or refrain from doing an act, which is empowered to do under this act or the rules or regulations. Then in case of failure, comply with such other, same shall be enforced in the manner as may be prescribed. This is what I really wanted to say. Enforcement is always there.
Enforcement of an order, my lord, passed by, my lord, the authority.
Yeah.
What if, my lord, the authority doesn't have the power, my lord, to pass that order?
That is what is the power is so wide that it says that has power to impose penalty, interest in regard to any contraventions, they guided by the principles, everything is there. So that is what I was just thinking about it.
No, my lord, this, if you see one, my lord, it says
I think it's contravention of
interest,
the obligations.
penalty or compensation imposed on him by the adjudicating officer. So, my lord, my point would be the adjudicating officer will have to have the power to make such an order of specific performance. Execution will come later, my lord. I want to, my lord, go through it and then come.
Keep Consumer Protection Act and this act side by side and then read.
I'll go through, my lord, and
But as a matter of procedure, I'm aware that before the RERA execution cases are being regularly filed.
we are not even at the stage of
I know,
execution. I
just-
mean, I'm not disputing the dictum of 40.
Is it now working?
Yes,
With full complement?
That's good.
it's working, but long dates are given.
Why?
In our case, only we get dates after every 3 months, and they give only half an hour time slots.
Oh, why long date?
I beg your lordship's pardon?
Why?
Long date?
I don't know. And only half an hour time slots are given
Then
for every case.
No, that is true. That's a very innovative way of doing it. But why long dates?
It's not that there are
No,
many,
no,
that
3
many
months.
cases.
3 months is still better. Land tribunal. No, land tribunal. 1 year. 1 year. The next date. My lord, I went to do a matter in August, and after we completed part of our submission, the date was given in September on a particular day, 18th or 19th. So I said, my lords, I'm busy on the 18th. Can it be 20th or 26th? So they said, Mr. Counsel, you're busy. 2025, it was last year, 2025, September 18th, you're busy. I said, what? 1 year. It's unthinkable.
No, actually it is, this RERA is in a formative.
Yes, but I
thing,
think it functions better than,
drawing.
yes, it's good.
Efficient. So I think the chairperson is very, very active,
Yeah.
proactive.
A new chairperson has come in about 2 months ago.
No, that is in RERA. I'm talking about the chairperson of the appellate authority.
Oh.
Appellate authority.
He is very proactive. He really regulates.
Yes, Your Lordship, it's a more formative, my lord, stage. So,
Because there was a HERA.
yes, that was
declared to be
correct,
ultra
correct,
virus.
correct,
HERA has to be,
correct,
and every appointments and everything has to be done.
correct, correct.
That's right.
Let us see, let us please consult that.
Absolutely. I'm
If you
grateful.
Can can you give me that?
Phone. Call on your phone.
Judgment,
Take out the-
judgment. Yes, sure. No, the hard copy. কোন জাজমেন্টটা আমি দেখে নিচ্ছি করতে তোমার একটা জাজমেন্ট বার করতে হিমশিম খেয়ে যাচ্ছে হচ্ছে না কেন sit down please Indira Mukherjee to ACDCL WBSCDCL na income tax
Neither. District Consumer Disputes Commission. NOO.
not A
Namaldiba ঠিক আছে Mukherjee MOO instead of you. No, M is fine.
Oh, আচ্ছা।
Mukherjee double O.
KH na KE no results one no they've taken out the case but that's also Mandira Mukherjee. This is by this is Dilip set পেয়ে গেছি
Single no
2004 তো 2004
সবকটাই একই বোধহয়
different citations
What is relied? I think the France B. Martin's judgment is of the Supreme Court is relevant.
that's 1999 मतलब the 6 Supreme Court cases
I think you go through it.
Very well.
The complete answer, I think, to the issue. Can we give it day after tomorrow?
Any date, my lord. I can
Lord,
come back tomorrow. Whatever the needed hardships.
Day after
Day after
tomorrow, my lord,
tomorrow.
I'll be in some
Tomorrow.
difficulty. Tomorrow better.
It continuing matter bole tomorrow regular.
Grateful, my lord. My lord can keep it with the file.
Do to him. Grateful.
Grateful.
Uh, 61, I'm for the appellant plaintiff, my lord.
কত আছে 61
It's a partition suit, my lord. I have partition suit. I have 1/4 share over the suit property, my lord.
just one. You are against receiver,
Receiver and accounts, my lord.
just eight approved. Serve the notice.
My lord.
Yes, the appeal is formally admitted. The appellant is directed to serve the copy of the application. You have applied for a fresh receiver here.
My lord, but in the original plain, my lord, it was me, the prayer.
I am asking you application.
Yes, my lord.
Let me see. Yes, application for receiver upon the respondents by speed post, as well as the learned advocate representing them in the trial court by hand, and shall file the affidavit. Which court?
My lord, Alipur, my lord.
Yes, by hand, and shall file the affidavit of service on the returnable date. The appeal is returnable. The application is returnable on 20th.
Yes.
No, not on 20th. Sorry, on 22nd.
Grateful.
22nd.
My lord, it's my appeal, my lord, from the order dated 22nd May 2024, my lord, whereby, my lord, the learned court below.
Who are you? First tell me.
I am for the plaintiff.
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 And what is the suit for?
My lord, suit, my lord, is for cancellation of the deed of conveyance, my lord.
Cancellation of the deed of
executed by me.
conveyance. Cancellation of the deed of conveyance
Conveyance. And this is the basic prayer, my lord, in the suit.
and what
And
is
my
the
lord,
nature of the impugned order?
nature of the impugned order, my lord, we have sought for an injunction
Refusal.
restraining the defendant from creating third-party interest.
Refusal.
Refusal.
Ex parte stage.
It was on ex parte, they appeared, my lord. Thereafter, they had court did not grant an interim order of injunction. The only injunction which was prayed for was not to
No,
create
no,
third
no.
party.
You are asking for an injunction,
Yes.
not to create a third party interest.
Yes.
My lord,
Just
I
one
appear
minute.
for
On
the
the basis of
respondent.
the said deed of conveyance.
Just give us 30
Yes.
seconds time to go through the impugned order. Was this money of 1 crore 99 lakhs paid and shown in the deed of conveyance.
My lord, it was not paid. The memo
How
of
you executed
consideration.
the deed of
My
conveyance?
lord, a check number was mentioned without any date, but it was never handed over to us. And this money is not been paid to us, 1,99,50,000. And my landlord cannot show that this money was paid to us.
Where is that provision in the Transfer of Property Act that if the entire consideration is not paid and the execution is done, then I think there is one provision.
No, the contract becomes void, my lord, if the consideration is not passed on.
No, that is a different. Who is for the other side? Defendant number 2. He is in his favor. The execution was done.
Yes.
Yes.
That's me.
Are you contemplating to transfer or to let out this property to anybody? Tell us.
As of now, no.
No.
But
So-
before that, my lord, we have my lord submissions to.
We will injunct it.
No,
first.
my lord, there is already an order of injunction. My lord, I need to show that.
Where is an order of injunction?
My lord, we have filed a suit.
Against him, the
Yes,
injunction.
where my lord, we have got an order of injunction. And my lord, this money has been passed on. And my lord, we have proof of that.
দিয়ে দাও ছেড়ে দাও ওটা যে দেখাচ্ছে দেখি।
We have not been served.
My lord, there
Can I
are two
have a
matters. My lord, there are two orders.
Can I have a copy?
And my lord, the order has been communicated to my learned friends, client, my lord, in my lord, compliance of order 39. দুটো না না দুটো মামলা তো দুটো কপি
Can I
দুটো
have
ম্যাডাম এই মুহূর্তে নেই আচ্ছা এটা আরেকটা মামলার কপি
a
ম্যাডাম একটা নিয়ে আমি দিতে চলে আপনার মক্কেল পেয়ে গেছে অর্ডার থেকে
I want to see.
Just wait. This is now practically a civil bench, so you know.
Yes, yes, my lord, I
Mr.
just
Banerjee
wanted
may
it that I
come
should.
many things. Let me understand
Yes.
the situation. Don't worry. Let me understand.
but I'm sure my lords are not annoyed with me.
No, not at all. I know the entire modus operandi. What happens?
But I
Don't
wish,
worry.
my lord, I could disclose who is the ultimate beneficiary.
Ultimately, let us see. Where is your plaint?
It's not annexed.
Yes.
I've got a copy of the plan, my lord. This is.
নম্বরটাই দেখলে আমার নম্বরই দরকার আছে দেখুন
Two planes, my lord, suit. একটা এটা দিয়ে দিন, my lord. I didn't.
Sorry.
Can you just see the.
আছে আর কপি আছে নাই তো লুকোচুরির কোনো ব্যাপারই না
আমি জানি না।
এই যে ভারতে কে আছে কে আছে অঞ্জন আছে তো অঞ্জনকে রাখো কে আছে কবে থাকতে হবে
हाँ ठीक है ठीक
But I have delivered a copy. Supplied a
Just now
copy.
my learned friend has
Hey,
given
just
one
now,
copy
just now,
Milord,
I've supplied.
if yes no Milord, what I submit Milord. There are two suits filed, no? Can you give me another
I'm
copy?
not a copy. Sir.
Very well. Deeply obliged.
This 15th floor flat, Milord, is now under occupation of Mr. Shobhan Chattopadhyay.
What?
This 15th floor flat, Milord, is now under occupation of Mr. Shobhan Chattopadhyay, for which, Milord, money has been paid by us.
No, no.
By whom?
Mr. Shobhan Chatterjee.
Who is he?
Milord, a person, Milord, who had no manner of transaction, Milord, with all
Why
this.
you give a name?
I give a name because,
Calm for the name.
no, Milord, there is something. Milord, this flat was handed over, Milord, because of some extraneous considerations, Milord, to some particular person. And Milord, for that money was taken from us, that flat was not given, and it was understood that, Milord, that would be adjusted from
I have
this.
read it. That's why I say,
Right.
more you argue, more you will make them wise.
Right.
Let them become wise. I have seen what you have pleaded.
Right.
Yes.
Duty printed.
Milord is not passing any order.
Identical.
It's simply being adjourned, Milord, no order is being passed. Right.
Milord, I'm appealing for the respondent number 2. Your Lordship, I am for the appellant in this matter. Your Lordship, one humble submission. This is a change brief, Your Lordship. We need some time to prepare and come back before Your Lordship. If Your Lordship be kind enough to grant us some time, Your Lordship, to come back.
I think you have chosen a wrong judge for this ground.
Your Lordship,
When you take a
humble
change,
submission, Your
when
Lordship.
you were so, I think, emboldened enough to take the change, you should owe the responsibility that you have to, you should prepare yourself.
Your Lordship, I bow down to that.
And this can't be a
Absolutely
ground
correct.
to give an adjournment.
Nevertheless,
I have got a strongest of aversion against the change brief. In my career, there not a single. Never.
But
never ever.
I can very well understand, Your Lordship, but still I'm making one humble submission.
Why? Then
If Your Lordship
were
kindly
aware
gives us
that
one
matter is
chance, Your
pending?
Lordship.
You were aware that this matter is pending in the.
Yes, Your Lordship. Yes, Your Lordship. It is there in the list.
Then it is your responsibility to prepare yourself. If you cannot, then this can't be a ground. Maybe in some other forum, these are the grounds, but not at least before this court. Definitely not. Do it, or we'll decide.
If Your Lordship kindly keeps the matter next week, we will come back and.
No, don't come back. You have come today. Do it. Where is the current order?
Your Lordship, if Your Lordship kindly comes to the supplementary affidavit. Because the order that is,
Oh, supplementary, I'm not getting it.
should there must be a supplementary affidavit so far as,
Supplementary, I got it. Yes, page
Your Lordship, kindly come to
19.
19, yes.
19 is the order 39 rule 7.
No, my lord, order number,
About
order
injunction. Oh, at the top.
top.
Yes, Your Lordship. 10/1/2023, Your Lordship, the order.
What has happened to the injunction? Identity?
It is pending, Your Lordship. It is pending. So,
Order 39 rule 4 is allowed.
yes. This order was modified by the order dated.
Yes, sir. Tell us.
No, my lord,
How, under what circumstances the court can?
no, my lord, two
Yes.
things. My lord, this is a suit for partition.
Under-
My lord,
under
at ad
order
interim
39,
order,
Please take the civil procedure court. Tell us that under order 39 rule 4, the court can do it. Please do. Read it.
my lord, I have.
Read it. Oh, you have. Read.
No, my lord, if my lord takes order 39 rule 4,
Please, order 39 rule 4. Please
any
read it.
order for an injunction may be discharged or varied or set aside by the court on application made thereto by any party dissatisfied with such order. Now,
First condition,
first condition,
dissatisfied.
yes.
You are not a dissatisfied
Yes,
person.
my lord, I filed a application, my lord, for variation of the order. Yes.
You are not dissatisfied. Second,
Second,
what further read.
provided that if an application for temporary injunction or in an affidavit supporting such application, a party has the knowledge made a false or misleading statement in
You are a
relation.
plaintiff, so you cannot say that any.
I am
false statement-
defendant. I am defendant.
Oh, you are defendant. So have you made a false statement?
My lord, why should, my lord, they have made a
I'm
statement.
asking, have you asked for a false?
My lord, I said before the court, I am aggrieved by the ad interim order where, my lord, a status quo has been granted over the property while I was raising a construction.
This is not a case. You wanted a modification. I am just asking you. So there are two conditions. First condition is that you are dissatisfied.
Yes,
Second condition is there is a suppression.
yes,
Tell us that if there is a suppression,
yes.
then why modification? It has to be vacated.
Now, my lord, kindly takes up my application.
Further,
Yes. I read from the provided part. Provided that if an application for temporary injunction or in an affidavit supporting such application, a party has knowingly made a false or misleading statement in relation to a material particular and the injunction was granted without giving notice to the opposite party, the court shall vacate the injunction unless for reasons to be recorded. It considers that it is not necessary so to do in interest of justice. Provided further,
it can only vacate.
yes. Now, my lord,
Modify.
provided further that where an order for injunction has been passed after giving to a party an
It is not a
opportunity of
case here. It is a contested order.
yes,
Second,
yes, second
provision
proviso is with regard to
order.
contested order.
It is not a contested order, ex parte.
Yes. Now, my lord,
Tell me, where is your application under order 39?
yes, kindly
How
takes
the
up.
court can permit you to make.
My lord, takes up
construction?
my application, my lord, on order 39 rules.
How can a court make you permit you to make construction?
My lord,
It will vacate, it will vary, I can understand, but permission in this regard, tell me under order 39 rule
my lord,
4,
kindly takes up my application.
please tell us.
Page 48.
Page?
48 of the stay application.
Yes. Yes.
Now, my lord, prior to this, my lord, kindly takes up their application, what they have prayed for. My lord, apropos.
Forget about what they have prayed for.
Yes,
They have prayed for a partition.
yes,
It's a partition.
partition suit.
In that, they have filed an application for temporary injunction. The court passed an ex parte ad interim order injunction. status quo with regard to nature, character, and position
Yes.
of the co-scheduled property. I am simply concerned with this.
My lord, can you take up then page 48?
Yes.
Now, my lord, what I have said,
Can this be regarded as Order 39 Rule 4 application? Tell me.
my lord, kindly
I
take.
have seen the prayer.
Yes.
Can it be regarded as
My lord, the prayer,
Order 39 Rule 4?
yes.
Tell me.
My lord, the prayer is, my lord, with regard to the modify
No,
of.
sir, please look at, read the prayer, what you have
Yes.
said. Please.
Your honor be pleased and allowed the petition for new construction at the southwest vacant Bastu
Correct.
as residential house of the defendant number 2 as per the engineer plan estimate over the suit plot number such and such
Correct.
by modifying the injunction order.
Yes. I am asking you,
Yes.
how?
Now, my lord,
How?
I was raising a construction in my own plot which I have purchased. My lord, it's not demarcated. I say, my lord, it's not demarcated by a partition suit, but it was, my lord, sold. We are all brothers sisters. Now, my lord, he has purchased some portion in the plot from the same vendor. I have purchased the plot from the same vendor. Now he is in possession of that plot. He has raised his house. He has raised his house. There is an old structure where we used to reside in that plot. That plot is in dilapidated condition. What the further plot we purchased, my lord, in that portion we are raising our house.
Say that you were residing in that portion, then you purchase. I do not know. What is the concern?
Well, from the pleadings, it will appear he says that my portion is specific and it's a southwest corner.
Tell me that what was the initial nature of the property?
Initial nature of the property, my lord, the property is dark number 2915 is the initial property in
I
question.
do not want.
Now, my lord, there was an old structure there.
Owned that property.
Yes. Kindly takes up.
That
Yes,
property
Lord,
and
kindly.
then how
Yes.
you purchased it.
Yes, yes. Kindly takes up the stay application, my lord. Takes up the plaint at page 15. My lord, the averments will be clear, my lord. My lord, I read
What
the
was-
specific.
Then what for you are engaged?
Yes.
Tell
Now, my
me
lord.
the crux that
Yes.
what has been said.
Paragraph
Who owned-
8.
I just wanted who owned the property,
My lord, the name.
who was the original owner,
Mm,
or where the original owner.
yes.
Supplementary evidence, page 11.
দাঁড়া এইখানেই নামটা আছে, নামটা আমি বলে দিচ্ছি।
ওখানে ট্রান্সলেটেড কপিটা রয়েছে।
ট্রান্সটা না, আমি বাংলাটাই পড়ছি। স্বদেশ মাইতি।
Was a single owner.
No.
Yeah.
নামটা কোথায়?
You both have not come ready.
শুরুর দিকে
The law will take us the second seat unless the fact is.
Yes, that's why I say, my lord, the paragraph 6 from the plaintiff, my lord, takes, my lord, the description.
Is 29. The Radhesham Das was the owner.
Page 29.
He sold the property to Swapan Kumar Maiti.
Maiti, yes. Swadesh na Swapon Maiti.
And Rajkumar Maiti.
Maiti.
That both the plaintiff number 1 and the defendant number 1.
Yes.
And they were minors, so their father, Rishikesh Maiti, got the position.
Yes.
Then after purchase, they constructed, Rishikesh Maiti constructed a beetle plant.
Yes. Now, my lord, in my written statement, paragraph H, page 31, the Naren Chandra Maiti and Swadesh Maiti.
It is by way of an arrangement. They claim that they have, they claim that this was divided amongst the
Yes,
two brothers.
amongst the brothers.
Swapan and Rajkumar.
Yes.
So,
now, my lord, takes up, my lord, page.
Is Swapan or Rajkumar?
No, my lord, from Swapan Rajkumar, kindly takes paragraph H. What happened, my lord? The suit plot belonged to Naren Chandra Maiti and Swadesh Maiti. They declared to sell. And as per open majlis and after taking consideration by Naren Chandra Maiti and Swadesh Maiti, executed a sale deed in favor of defendant number 2 that is Orpona Maiti, the wife of defendant number 1. And it comes to page 30. That's my written statement. In the co-scheduled property, giving specific portion in the suit plot. Now, this suit plot entirety was not divided as per required under law, but it was amicably possessed by the brothers, sisters. This plaintiff and the defendants, plaintiff and defendant number 1 are brothers, and defendant number 2 is the wife of defendant number 1. So, wife purchased from the original owner another portion in that southwest portion. Now, in the plaintiff,
How can a construction be permitted?
Now, I tell your lordship, kindly
Just
take up the
under Order 39 Rule 4, tell me. I do not know, please make me understand, make me.
Now, suppose, in an ad interim stage, the facts pleaded as per plaint, and if I file an application at the ad interim stage,
Injunction will be vacated.
Vacated.
That's all.
Yes.
Not permitting you to make construction. The court cannot substitute it. The court does not know.
It
that
can
you
be
have got a
nominated
sanction clause.
if my lord
The
says.
court does not know that how this has come. Was there any objection which is raised? Nothing. And the court has permitted you to make construction.
No, this Order 39 Rule 4 was an objection was filed. It was on contest.
Then the injunction be decided, this permission cannot be granted. If it is vacated.
Today, the
that's all.
construction is complete. Construction is
completed the
complete. We have completed. Now, it was injuncted at a stage where it was half done.
What remains then? What remains?
Your lordship,
Bring that judgment of 2008, volume 11 or 10 SCC, page 1.
Yes, I have brought that.
You have brought, give it to him.
811 এনেছিলাম না?
Finance judgment.
না 811 এনেছিলাম।
Volume 10 or 11?
Not volume, এক মিনিট দাঁড়া। এনেছিলাম ওটা। না।
তুই এটা বলছিস
না, 11 8 এর 11
দেখে নিচ্ছি।
আরে ওই মামলাটাতেও তো যাচ্ছিল রে। না, না।
8-11 SCC 1 দেখে নিচ্ছি।
হ্যাঁ 8 এর 11 SCC 1 page 1.
your lordship, one humble submission I can make. Since the construction has been done, and if
takes up page 42. My lord need not criticize the learned trial judge. My lord, we should have apprised, what has happened factually. My lord, page 42 of the stay application. My lord, the ad interim order, which was
Affirmed.
passed, affirmed, and order 39 rule 4 was fixed for hearing.
So it is not pending.
No, not pending.
Have you got that judgment?
Yes, Your Lordship. I have got it.
Favorite.
Read that judgment?
Favorite.
Volume 11 or 10?
11. 811, page 1.
Page 1. Right hand side,
Yes.
paragraph 24, 23, 24, 25.
Yes.
Yes.
What I said, rightly or wrongly, the
Wrongly, the-
construction has come up.
Paragraph 26, Your Lordship.
Yes, that is what I said.
26.
And then the two paragraphs, conditions were imposed, just last penultimate paragraph,
Yes, Your.
not in this page, reverse page, left, yes, on your left hand side, top. These are the conditions. The present appeal arises from an order number 26 dated 25/1/2024 passed by the London
এই আছে না 73 আছে না
73, 76.
76 টাকা।
For the respondent.
Where the suit for partition and injunction filed by the respondent matter, I am the defendant, sole defendant.
Appeal arise from
And there are the expertise order of
Order 39 Rule 4 rejected.
rule for rejected.
Just give us 30 seconds time.
Fine.
Not to make any further substitution. Ulto. Have you got the sanction building plan?
Yes, ma'am.
Where is that? The court has
Under
said
the
that
court,
you did not
Maharashtra,
file.
the court below, the largest advocate, represent the court below not been tendered matter at the time. I have annexed.
File your opposition. Yes, appeal is formally admitted. After hearing the party, we feel that an opportunity must be given to the respondent to file affidavit to the amendments made in the instant application. Let affidavit in opposition be filed within 2 weeks from date.
Fortnight.
Reply, if any, shall be filed within a week thereafter. The appeal and applications are made returnable after 3 weeks.
While they will liberty to file a supplementary affidavit because my lord, the stay application with prior is not, my lord, the appropriately.
Leave is granted. Leave is granted. Leave is granted to file supplementary affidavit. Let the supplementary affidavit filed today be taken on record.
Yes.
Affidavit in opposition both to the application as well as supplementary.
Supplementary. Grateful, lordship.
3 weeks.
Next.
66.
66, my lord, I appeal for the opposite party number one.
Amit Baran Das is appearing for the appellant. He instructed me to for short possible to take up this matter at 2 p.m. if possible, your lordship. Because he is on legs on another court, your lordship.
But copy of memorandum of
Amit Baran Das. Amit Baran Das.
But what's your good name?
My name is Subhrajyoti Ghosh.
Where is Mr. Mrinmoy Chatterjee? Who is that?
Lordship, as per instruction, I am submitting.
Lordship, this matter, I am in Macharaji. I give my NOC in this matter, Lordship.
Well, memorandum of affiliate stay application has not been served upon.
You are not entitled to memorandum of. Under the law, you are not entitled. The application, why don't you serve?
Which?
Sorry, not today. Serve the copies.
Lordship.
Next.
67.
7, Lord, I am for the appellant.
Appeal for the respondent number 1. Sir, quick.
There was a previous order pursuant to which, my lord, I served my learned friends. But I am the defendant in a suit for a declaration and for recovery of possession, branding me as a licensee. My defense was that, my lord, by virtue of a 1958, my lord, the deed of gift, I became the owner of the property. Thereafter, my lord, there was a partition.
Deed of gift by an admitted owner.
The predecessor of my learned friend, the plaintiff. My learned friend is, my lord, appearing for the plaintiff. They filed a suit praying for a declaration that, my lord, the deed of partition
So they are claiming through their predecessor, and according to you, their predecessor during his lifetime executed a deed of gift in your favor.
Yes. And Lord, also Lord, in respect of the 12th decimal of the property, Lord, I have an independent title in respect of that property. On dint of that, Lord, there was a partition which was executed in the year 1982.
Okay.
In the partition, plaintiff number 2, Shushanto Chaudhary, he subscribed to the partition deed. It was a registered partition deed. That registered partition deed was not the subject matter of challenge by of a suit of declaration in the year 2003. So a point of Article 59 of the Limitation Act was taken as to whether the suit is at all maintainable to seek a declaration by a executant beyond 3 years.
In this is not that suit
This is that suit.
where they challenge the.
Yes, the first declaration is, yes, the first declaration. I'll
Okay.
plaintiff
So plea of 59 was taken.
And that was one of the questions framed by the first appellate court as a point of decision.
Okay. What the trial court did?
The trial court said that the deed of gift which I produced.
On limitation.
On the limitation, the learned judge said that because they took out a certified copy and
Trial court.
The trial court.
Okay.
And therefore the question of limitation was overlooked. They say it is their contention that in respect of the partition of the year 1982, only plaintiff number 2 was the signatory. The other co-owners were not signatory. Therefore, the deed was not binding on the other co-owners. So, that doesn't go to say that the challenge thrown to the partition deed is within limitation. 2003, the suit was filed. Plaintiff number 2 put his signature in the partition in 82.
But last sentence I could not understand.
Their contention was that in the partition, only Sushanto has signed.
They did not sign, so it will not be deemed to be
a valid partition.
Valid partition, and that is not binding on them.
So that doesn't tell upon the question of limitation.
It does not.
So this question of limitation is a substantial question of law in this appeal. Whether they could have at all challenged the partition of 82 in 2003.
Why when they derive knowledge of this?
But according to us, in the written statement,
have they stated anywhere in the plain that they derive knowledge?
No, I will just point out one page, in the written statement.
Had they be a party to a deed,
Lordship,
one can have that they have a sufficient knowledge of the deed.
The plaintiff number 2 is a party to the deed.
So far as the plaintiff number 1 is concerned,
his mother.
Maybe.
His mother.
So what?
The mother
does not have.
Yes, but the plaintiff
He had a right in the property.
True, but so far as the question is that when she got the knowledge of this particular deed that is stated in the plaint. আর আমাদের রিটেন স্টেটমেন্টটা বলা আছে না আমাদের আগে রিটেন স্টেটমেন্টটা বলবো যেখানে বলছে ওরা এই পার্টিশনের কথাটা বলেছে I'll just read page 64 of the stay application being my the written statement.
They are plain.
No, my written statement.
They are plain. Because they have sought for the declaration.
Lordship.
You are taking a plea of limitation.
Because I have in the written statement said that they knew about the execution.
Sir, what they have said, the plaintiff number 1.
Lordship. Lord, at page 58, Lord, may I just read it? It's in Bengali, Lord. Nalishi. Huh?
Handwritten or typed?
Handwritten. Handwritten. But I'll start from page 57. about, my lord, last 7 lines. তাহারা যতীন্দ্রনাথ কাব্যতীর্থের ত্যক্ত সম্পত্তি আপোষ ভাগ বাটোয়ারা করিয়া লইবেন, যাহাতে ভবিষ্যতে অসুবিধা না হয়। বিশেষত যতীন্দ্রনাথ কাব্যতীর্থের নাম কোনো রেজিস্ট্রি দলিলে না থাকায় একটি রেজিস্ট্রি বন্টননামা করিয়া লওয়া আবশ্যক। 1 নম্বর বাদিনী অশিক্ষিতা গ্রাম্য মহিলা, তিনি ভ্রাতাগণ ও মৃত ভ্রাতার পুত্রগণকে বিশ্বাস করিয়া পিতার ত্যক্ত সম্পত্তি বিভাগ বন্টন করিতে সম্মত হইলে তাহা বলেন কেবলমাত্র পুরুষ মানুষরা সই করলেই দলিল করা যাবে, মহিলা অংশীদাররা সই করার আবশ্যকতা নেই। সেই মতো 1 নম্বর বাদীর উক্ত ভ্রাতুষ্পুত্রগণ ও ভ্রাতাগণ বিভাগ বন্টন দলিল প্রস্তুত করিবার ভার লয়েন এবং আদি সুশান্ত কুমার চৌধুরীকে রেজিস্ট্রি অফিসে ডাকিয়া লইয়া ওই দলিল সই করিয়া লয়েন। ওই দলিল মিন্স দ্য বন্টননামা ইজ পার্টিশন। এই বন্টননামা দলিল যাহা নালিশি কষ তফসিল বর্ণিত হইয়াছে, বাদীগণের মধ্যে কেউই পড়িয়া দেখেন নাই এবং তাহাদের পড়িয়া শোনানো হয় নাই। সুশান্ত কুমার চৌধুরী সম্পত্তি বিষয়ে সম্পূর্ণ অজ্ঞ থাকায় এবং নিজ মাতুলদের ওপর ও মামাতো ভ্রাতাগণের উপর অগাধ বিশ্বাসে ওই দলিল না পাওয়ায় না বুঝিয়া সই গ্রহণ করিয়া চলিয়া আসেন। বাদীগণ কেহ ঘুণাক্ষরেও জানিতে পারেন নাই যে 1 নম্বর বাদীর ভ্রাতুষ্পুত্রগণ ও ভ্রাতাগণ তঞ্চকতা করিয়া নালিশি দাগে 24 শতক জমি ওই বন্টন নামভুক্ত করিয়া তাহাতে বিভাগ বন্টন করিয়াছে। নালিশি দাগে বিবাদীগণের বা তাহাদের পূর্বাধিকারীর কোনরূপ সত্ত্ব না থাকায় ওই জমি নালিশি যে বন্টননামা দলিলে অন্তর্ভুক্ত করিবার কোনো প্রশ্ন নাই। বাদীগণের পক্ষে সুশান্ত কুমার চৌধুরী গত ইংরাজি জুন মাসে খাজনা দিতে গেলে তহসিলদার তার কাছ থেকে সম্পূর্ণ নালিশি জমির খাজনা লইতে অস্বীকার করেন এবং বলেন নালিশি দাগের কেবলমাত্র 12 শতক তাহার নামে লিপি হইয়াছে, সুতরাং ওই পরিমাণ জমির খাজনা তিনি দিতে পারবেন। অবশিষ্ট 12 শতক বিবাদীগণের নামে লিপি হইয়াছে, তাহাও তহসিলদার মহাশয়ের নিকট বাদী সুশান্ত কুমার চৌধুরী শুনিতে পান। তখন তিনি বিএলআর অ্যান্ড এলআরও অফিসের যাইয়া খোঁজ করিয়া জানিতে পারেন যে বাদীগণকে কোনো নোটিশ না দিয়া নালিশি দাগের ওই এলার পর্চা পরিবর্তন করিয়া বিবাদীগণের নাম 12 শতক লিপিবদ্ধ হইয়াছে। তখন বাদী সুশান্ত চৌধুরী খোঁজ করিয়া আরো জানেন যে একটি বন্টননামা দলিল দৃষ্টে এইরূপ রেকর্ড পরিবর্তন করা হইয়াছে। এই কথা শুনিয়া বাদীগণ খোঁজ খবর করিয়া 28/8/2003 তারিখে নালিশি বন্টননামার নকল তুলিয়া সর্বপ্রথম জানিতে পারেন যে তঞ্চকতা মূলে নালিশি দাগের জমি উক্ত কবলাভুক্ত করিয়া তাহার অবৈধ বিভাগ বন্টন করা হইয়াছে। So
knowledge is derived from a date.
The knowledge is derived from, Lord, the PW2, the second plaintiff is a party to the deed. Rest, Lord, the plaintiffs, they say that when, Lord, they went to the office of the BLLRO to tender, Lord, the ground rent, they came to know that in respect of 12 decimals, it is recorded in the name of my client, the Bivadi, and 12 decimals, but they refused to take, Lord, the rent, ground rent. Then they came to know about that there was an execution of a partition deed, took a certified copy on 28th August 2003, and thereafter filed the suit. So, Lord, the first prayer that they made in the plaint was, Lord, for a declaration that, Lord, this partition deed is not binding on the part. And the other prayers are, Lord, in respect of this property where my client had already constructed building, they sought for, Lord, the removal of the construction and for recovery of possession. In the written statement, Lord, I took a plea and, Lord, I produced, Lord, the documents. There are 2 deeds of gift. The 2 deeds of gift, Lord, which follows, Lord, my title to the property. These are marked as exhibit A.
No, what is that 2 deeds of gift?
Lord, from the predecessor in interest of the plaintiff, Lord, I got the property. I can show, Lord, the observations of the learned trial court on that.
So then what was the occasion? What was the
This
occasion for
document was not,
bondnama?
Lord, challenged even in the plaint.
Then if that was done, then what was the occasion for execution of a bondnama?
Because, Lord, by virtue of that, they admit that I am one of the co-sharer. Their case that they are running, that I was not a licensee and occupying the property, that is demolished.
So there are two aspects. One is that the predecessor has given the entire property to you by way of a gift or a portion of the property.
The portion of the property.
So you can be regarded as a co-sharer along with them. So they are not saying that you are not a co-sharer. Why they will say the deed of gift? But what they say that this Bonton Nama, by virtue of this was separated. This is not correct.
That is not the subject matter of challenge,
Right.
but the learned trial court as well as the
So if you did not get the whole of the property or the share of the predecessor in interest, then the remaining share, the property, they have inherited.
that is not where the trial court and the appeal court says that not the gift deed of the year 1958 is a blood act of forgery. That was never subject matter of challenge. I'll show Lord the prayers in the plaint. Yes.
So, no, the finding of the court.
Lordship.
Have they declared this also?
Yes.
Where is that?
Yes. No, Lord,
The plaint? Towards the
first,
plaint?
Lord, in the plaint, your Lordship will kindly see the prayers, Lord, for once.
Judgment?
No, no, no.
No.
Hmm?
The handwritten judgment by the trial court.
Lordship, by the trial court. As well as by the Lord, it was a judgment of affirmance.
No, that is the type 1, the appellate court.
Appellate court is the type 1.
Where is the finding of the trial court?
Lordship. আমি তো memo of appeal থেকে দেখাচ্ছি। Now, Lord, your Lordship will kindly come to page Lord, page 7 by 112, Lord, on the top. না আমি এই পাতাটা দেখছি 7/110 থেকে শুরু করি মেমো অফ অ্যাপিল
Yes, 7 by.
But on the top, your Lordship will find Lord, it is about 7/110.
Yes.
Now, Lord, at the first time of our argument, learned advocate for the plaintiff submitted that it was Jitendranath Chattopadhyay who got the suit plot number 222.
Where?
Lord, about Lord, fifth line from top.
No, 110.
Lord, 7/110, Lord, on the
Yes,
top.
I got that, 7/110.
Then this paragraph.
Yes, the learned advocate for the
At the
principal, defendant number 8.
No, pro
forma defendant number 18. Not plaintiff.
Oh, achha. Yes, learned advocate for the pro forma defendant number 18 at the time of argument submitted that the alleged partition deed is not correct as because in the year 1981, sons of deceased Shotendranath Bhattacharya told him that they are going to partition the property of Jitendranath Bhattacharya among the legal heirs. But as the defendant number 18 was staying in the Kolkata, for that reason, he was not fully aware of the properties of Jitendranath Bhattacharya. And due to that, the defendant number 18 signed in the partition deed without the knowledge that female members were not made party to the partition deed, as he put his signature on the deed on the ground good faith. But subsequently, when he came to know that the sisters are not made parties to the partition deed, he requested the other defendants to rectify the partition deed, but the request was turned down by the defendant number 1, 2, and 3. Further submitted that defendant number 7 to 13 has no right to construct over the Ghaw scheduled property, and the defendant number 14 to 17 have no right to construct over the Ungo scheduled property. As such, the construction or illegal construction, he further submitted that as no claims are made against the defendant number 18 in this suit, for that reason, the defendant number 18 has nothing to submit against the plaintiff. At the time of our argument, learned advocate for the plaintiff submitted that it was Jitendranath Chattopadhyay who got the suit plot number 222 by virtue of a settlement deed being number such and such of the year 1948. and who transferred the said 24 decimal of land of the suit plot number 222 to the predecessor in interest of the plaintiff Shatrendranath Chaudhary and Horendranath Goswami. But Shatrendranath Chaudhary used to possess the entire 24 decimal of the suit land, and he died in 1959, leaving behind the plaintiffs, that is Mamata Chaudhary as his widow, Sushanto Chaudhary as his son, and Krishna and Ratna as his daughters, and accordingly the plaintiff inherited the 12 decimal of the suit property, being the legal heirs and successors. It is to mention here that Mamata Chaudhary is the daughter of Satyendranath Bhattacharya and sister of defendant number 2, 3, 4, 5, and 6. In the year 1962, Horendranath Goswami sold his share of 12 decimal of land of the suit property in favor of Sushanto Chaudhary, that is the plaintiff number 2, by which the plaintiff got the whole 24 decimal of land of the suit property. Then learned advocate for the plaintiff referred the document marked as Exhibit A and mentions that as per this document, Satyendranath Chaudhary gifted his share of 12 decimal of land to Satyendranath Bhattacharya. Bhattacharya is my client's predecessor. Just before this 2 months of his death, when he was sick, and is it really possible? Can a person who is dying or going to die take away the last roof of his family? It is not really believable story. Question mark. He further submitted that as per Exhibit A, the said gift deed is allegedly registered on 12/12/1958, and the stamp paper is purchased on 12/12/1958 from stamp vendor of Chagda, and the deed allegedly was registered in the first joint sub-registry office, Ranaghat, in the year 1958 in book number such and such, volume number such and such, pages such and such. But the plaintiffs, by placing their evidence, have been able to establish that the particular gift deed is vague and false. If learned court is pleased enough to go through the documents marked as exhibit,
These are the submissions anyhow, then,
Lordship,
then where is the finding? I'm just.
Lordship. Dear Lordship, will kindly come to the page 7 by Lord 123.
120,
Lord,
you have left it. Come by 7 by 120.
120.
First paragraph at the middle of the page. Here in the present suit.
It is admitted part of the case that the
No. Here in the present suit, two main questions are to be determined.
127.
7 by 120.
7 by 120. Yes, Lord. Yes, Lord, I got it. I got it.
Whether the deed of gift marked exhibit is executed by such and such, and as to whether the partition deed is correct or legal.
Lordship.
There it says that the deed of gift is invalid.
Oh. Then, Lord,
Yes.
page 7 by 123.
123.
Yes.
I'm looking at it.
The second paragraph. Now the question comes. গিফট ডিড নিয়ে কোনো ইস্যু হয়নি, কোনো প্রেয়ার ছিল না, প্লেনটা বার করে দাও।
Court has said it's the forced deed.
Yes, there was no prayer for setting aside that deed. 1958 deed, my lord, I produced by you of an exhibit.
Have they disclosed this 58 deed in their plan?
No.
No. You disclose the by way of a defense. Now they say that the deed which you are relying on is a forced one. It was neither executed nor registered anywhere.
Lordship.
And there was a dispute over the signature appended on the deed. The court has appointed the handwriting examiner or something. The report came. The
handwriting
court also, yes, examiner. Examiner is there.
Lord, a court exercise section 73.
No, 74 he exercised.
But he has
You
mentioned
don't-
about 74.
No, he talks about 74, but there was
But there is
also
no
a
evidence of blood. Only blood of the defendants. Blood there of the plaintiffs. There are only blood 2 witnesses. But page blood 7 by 125, second paragraph. I have carefully compared the signatures of Shotrendranath Chaudhary on the document marked as Exhibit A.
Yes.
So it was the court's comparison of the signature of an age-old document, which carries a presumption.
Now it is you have to prove that this is a deed of gift.
Yes.
Have you proved it by bringing the attesting witness? It was not there. Have you brought any evidence that it has been duly registered? Did you not?
Court has said that it is a registered and it was entered in book number such and such.
No, that is what your claim was.
That is a 1958 date. It carries a presumption of validity.
Section 90 does not. It only carries the presumption of due execution, nothing more than that. Now, it is a rebuttal. They have said that the court found at 7 by 125.
Yes.
It says that the signature, that is at the bottom, line about 3 or 4 from the bottom.
Yes,
it is also well established that there can be no such deed being Exhibit 1, being registered number such and such, in book number such and such. During the whole trial, there was not a single attempt made on the part of the contested defendant to establish the fact that the deed was actually executed and registered. So the court has arrived that it was never executed and registered. It was you who have to prove by way of an evidence to bring that it is registered. It's a forced document, and the court ultimately held it's a forced deed.
No, blood. I'll just try to blood.
Last time, it's a forced deed.
Forced deed. Exhibit 1.
I'll just try to blood.
Somebody has produced a document pretending that it is a registered document containing all the particulars. The court ultimately found that no, it was never. It is you who have to prove it. Why they will seek for a declaration in respect of a forced deed, which you disclosed for the first time in your defense.
Now, Lord, it was never, Lord, the plaintiff's case.
Was it reflected in the deed of partition?
Yes. That your lordship will kindly come. Lord, page 126, 7 by 126.
Yes.
It is also available from the partition deed, certified copy in question marked as Exhibit 3. Lord, the second paragraph. That the particular deed nowhere in the body of the Exhibit 3, the devaluation or description of the deed marked as Exhibit A is mentioned.
Correct.
Or discussed. Had it been a fact that was acquired and the same was made part and parcel of the partition deed, then the devaluation of the discussion of the document marked as Exhibit.
That is what I wanted, because the partition deed was silent. Montanama. There was no reflection of the deed of gift. You for the first time produced it. And ultimately they are not obliged to seek for a declaration on the basis of your defense. It is you who have to prove that this is the genuine document. Then the ownership's on them. And it is a deed of gift, sir.
Yes.
Under section 122, 123 of the Transfer of Property Act, it requires an attestation. And section 68 of the Evidence Act attracts to prove that.
Number, when a question comes before the court as to a validity of a gift.
No, it's not. The question is not a validity.
But
the question is whether there is any existence of this deed in the eye of law. Existence means there must be a registration which is done. Deed of gift is a mode of transfer. And if it relates to a immobile property, fetching more than 100 rupees value, then it has to be done by a written document and duly registered under section 17 of the Registration Act.
Lordship.
The moment you rely upon, but unique feature is that it requires an attestation.
Lordship.
And then section 68 says that attesting witness has to be called to prove it. If the attesting witnesses are not available, section 69, other subscriber, anybody who has to be called, you could have called the registration office with the records saying that it is registered there. Then section 90 will come into play, due execution. A more than 30 years old document, I can understand. Nothing has been done.
Lord, I understand, Lord, these are all required if, Lord, a particular deed is questioned within the 30 years of its execution.
Sir,
Now,
I
Lord,
fail
this
to
was
understand, sir. I think Mr. Bakshi sitting on the last chair will be cursing me. The way you are arguing, he will be cursing me.
Now, Lord, my contention, Lord, is that
Sir, you have taken a plea, one who asserts as a onus to prove. If you cannot prove that this is a valid document, then there is no question of any declaration to be sought.
But it was my contention that this was a valid registered document.
You have to prove it first. That
Took,
it is a
Lord,
valid
the
registered
responsibility on its shoulder. Lord, it is not that the plaintiff challenged.
It is not
It is,
necessary.
Lord, I'll take your Lordship to entire evidences, Lord, tendered by the witnesses. Lord, all that I have done is, Lord, that I have produced the date. I have had it marked as exhibit without any objection.
What? It cannot be. It should be after objection.
The
What are you talking about?
list of exhibit.
Should not be. I don't, the person who is taking so much of such an objection and without objection, I have doubts. I have doubts.
But kindly come to Lord, page Lord 7/104. Exhibit A.
There is no reflection anywhere. The court, it is only at the time of the evidence and the marking of the exhibit, you have to show this certified copy of that order on the day when it is marked exhibit. Or an evidence.
And your Lordship will
Show
see.
us the evidence. Who produced exhibit 1? DW1 or DW2?
DW1.
Show us the evidence when he tendered. Show us the evidence.
But I'm just trying to find out. আরে ওটা তো PW দেখছিস DW1 দেখ
Where is the evidence of DW1? Do the liquid test.
Okay, this one is not. I use liquid text, but this was done in the conventional web, the software.
My lord, when he has taken such a objection,
Lordship,
do you think that he is?
I have the entire property built up in this.
He will not raise objection at the time of marking exhibit. What are
Lord, at page 76A. No, that is the plaintiff's witness. Lord, I have raised construction on the basis of, Lord, the partition. I have raised construction in the property on the basis of, Lord, the gift deed.
Question is not that. The question would come when when they claim that the portion or the vacation is to be done, then the question of ascertaining the amount of the expenditures which you made for construction and all everything, they would be liable to pay. That is a different concept at all.
Their case is that I'm the licensee.
Have you proved that you have raised the construction?
Yes, Milord, it is their case. It is the plaintiff case.
Anyhow, then
They say that I have raised construction in the property. And my case is on the strength of your
we
acknowledgement.
are not going into this aspect. You take that point in the execution. Anyhow, to us.
Lordship, if I may be permitted to assist you, Lordship, it was the plaintiff was amended after the written statement was filed, and this denial of the document was incorporated in the plaint itself after the amendment.
Not claim you pray for a relief.
Yes,
these
that is what
documents
that was what our argument was as fell from Lordship, but that denial of the document was incorporated.
Not necessary at all.
Yes.
That is not necessary at all. Why you did not amend the prayer also? Seeking a declaration.
But
that it
fact
was not
was
within your knowledge for the first time when they disclosed, it came to my knowledge. These are the forced documents. Declaration.
It was not. It was stated.
এটা কোথায় ক্রস এক্সামিনেশনটা
Not cross-examination, sir. In your evidence, the evidence in chief, show us evidence in chief when you tender this document.
But just a moment.
No, you are not ready. Come ready tomorrow unnecessarily.
But I'll just try to assist your lordship, my lord, that portion, lord. No, but I'll come back tomorrow. I'll come back tomorrow, my lord.
Not today. You also bring the evidence.
Lordship, I'll try to.
Crossটা লাগিয়েছিস ওখানে? Great.
প্রুভ করা ডিপটিভটা ডিপটিভটাকে প্রুভ করে দিচ্ছে
হ্যাঁ
এটা না করে এগুলো করে এক্সিকিউট হয়ে গেছে বলুন কেসফুল ডকুমেন্ট
এটা শুধু not today করো continuing matter. মানে ফাইল গুলো পাঠিয়ে দাও না কেন আগে সময় এখানে বসে বসে নষ্ট করা হচ্ছে
defendants are the appellants are the
Yes, sir. You are a plaintiff.
no I'm the defendants.
You are appointed as the joint administrator. Then
I have challenged the appointment of the plaintiffs as
no,
administrator.
he is not appointed as a joint administrator.
It's not, it is his application.
No, rather he says that he has no objection if the defendant opposite parties are appointed as a joint administrator.
Along with the plaintiff.
Which one? Not along with the plaintiff.
The sentence are also in.
No, the question sentence is
I'm
very
reading-
clear.
I'm reading. As it is admitted that the defendants opposite party in possession of the property under the caption of the learned lawyer of the plaintiff has submitted that he has no objection if the defendant opposite parties are in the capacity. Full stop.
Please.
I hereby appoint.
No. I hereby appoint them as joint administrator. Means the defendants.
Then my clients.
Obviously, you're not your client collectively.
Yes.
So
all the defendants are before your lordship.
Yes, you are appointed. You are appointed. What are you talking?
Hereby appoint them as joint. Them means
Read. I am reading slowly. As it is admitted that the defendants opposite parties are in possession of the property under caption, and the learned lawyer for the plaintiff has submitted that he has no objection if the defendants opposite parties are in the capacity, means both in the capacity of an administrator, because they are in possession of the property. I hereby appoint them means the defendants, as joint administrator pendente lete, who shall be subject to immediate control of the probate court. Obviously.
If that be so, my lord, I have nothing to say.
Nothing to, that is what I am wondering.
But kindly clarify that. The only defendants are the joint administrator pendente lete.
Sorry, you don't. After reading the impugned judgment, the first point which struck in our mind is whether the appellant can be regarded as an aggrieved person. Obviously, in a proceeding for probate, the executor is not here.
The respondent is the executor. The respondent is the executor. He filed the application for administrator pendente lete.
কি বলেছি? And obviously, the question would be, who would be entitled to administer and manage the state of the testator or testatrix? Testatrix. Interestingly, an application was taken out by the executor to appoint the administrator pendente lete to manage the property comprising in the state left by the testatrix.
this one I'm seeking. In the impugned order, there is reference to certain documents which were handed up in the before the learned court below by the defendants who are respondents here in the court, which was not part of the any of the pleadings. If those could be handed over, and we can come back on any other day. In the impugned order, there is reference to certain record of rights being handed over, but we do not know what was handed over. It is one of the grounds in the appeal as well. If those could be handed over, and we can come back tomorrow, day after, whenever. It was not part of the written objection.
Not today.
Instead, not today, my lord, I am taking instruction from my counterpart.
Yeah.
Not today. But if it could retain his position, my lord.
Yeah.
Our appellant. My lord, some defects are there, my lord, curable. Some defects are there. Defects. My lord, curable defects.
Curable.
Your lordship has seen it the other day.
Don't remember. But do not remember. Who are you?
My lord, I am the defendant. My
Defendant.
lord, the litigation between the mother and the daughter. Daughter filed a suit claiming that property left by her father, he is the absolute owner.
He?
She is the absolute owner. The daughter is and the father died in 1951. My lord, in 1951, daughter had no right. Widowed estate was there under Women's Right to Property Act. And my lord, 1956 Hindu Succession Act repealed, making, my lord, the widow's property limited interest absolute.
Section 14(1).
Yes. My trial court held the dependent's right become absolute.
Dependent?
Dependent's right has become absolute. Therefore, daughter will not try and relying on a decision of a Chhattisgarh, my lord, appeal court held the daughter will inherit half, moiety of share. And this is the difference in my humble submission, my lord. And Chhattisgarh decision, Women's Right to Property Act was not applicable. In the judgment it is said. But in our state, my lord, it is applicable. It was applicable, rather. That is the point.
What both the courts have held concurrently.
Inaj, page 30. 30 key. Oh. 32 judgment 9. এটা কোথায় আছে? My lord, your lordship gets page 30, my lord, appellate court judgment, last paragraph.
Yes, page.
My lord, your lordship gets, my lord, appellate court judgment, page 30.
30.
Appellate court judgment, page 30. My lord, the mother are married second time in the year.
Married second time?
Yes. Married his brother-in-law, husband's younger brother. That is a point to be considered also.
What was that?
If it is prior to the marriage is prior to.
It is more progressive social aspect.
If it is
more progressive social aspect. This Leelabai was the daughter.
Huh?
This case. Doctor.
Huh?
No, no, in your case, the Leelabai was the daughter.
It is not their case. No, no. Their case.
My lord, page 30 point has been discussed at page 30. In case of Bela Bhai, this is through a last reported in such answer, my lord, online Chhattisgarh, plaintiff Abhiram. Oh. Lord, your lordship,
yes.
the decision is with us, my lord.
So, Mr. Bakshi, unless we know the fact, we can't enter into the law. Till this time, the fact is not known to me. You have started with this that the gentleman who was the owner died in 1951.
Yes.
When the Hindu right or the Women's Right to Property Act was invoked.
Yes.
You argued 1956 when the Hindu law was codified.
Yes.
And the Hindu Succession Act came into force.
Yes.
Then the woman's right to a property becomes an absolute right.
The right has become absolute.
But we are unable to comprehend that who was woman and whose right become absolute. Till
Wife's
now.
right. Limited interest.
I am just asking whose limited interest? The widows or the daughter
Widow's
or
interest.
what?
Your lordship is perfectly correct. Widow's interest. That is the my lord, forensic word.
But you will say the fact. You have not said a fact.
আর তো কিছু বলার আছে
এই ধরনের জাজমেন্টস গুলো লেখা হয় অ্যাপলেট কোর্টে পুরোটা একদম মেমো অফ অ্যাপিল যেটা আছে পুরো ছাপিয়ে দিয়েছে কপি করে দিয়েছে
কি বলছি আর এরকম মানে শুনতে পাই না কিছু না Women's right to property does not apply সেটা কোন জায়গাটায় বললো বলেন তো ওটা দেখুন আমাদের দাগ দেওয়াটা কোথায় দাগ দেওয়াটা না না ইয়ে না ডিসিশনটা
The dates are very confusing, Mr. Bakshi, because if you say this Lokhimuni, who was the widow from the first son, that is the Ashutosh, and the Ashutosh died on 4/2/1951. How can she married Khudiram in 1947-48? That was during the lifetime of the husband. The judgment really speaks of that. That creates a confusion. No. What is your answer? What is correct? Huh?
Yes, in 51, that is the concurrent finding.
No,
Prior to
I find in reply at page 15.
remarriage, remarriage 60, trial court has found, appeal court also accepted that.
But at page 15, the argument stage, I find 47, 48.
If the marriage has been, my lord, within the period, before 56 Act, the daughter would have inherited.
No, I got your point. Now I got your point. Your contention is that if on the date of coming in force of the Hindu Succession Act, the widow was a widow.
Yes.
Then, by virtue of section 14(1), her limited interest or limited right becomes absolute.
Absolutely.
It is immaterial.
56
It is immaterial that she remarried after 56.
Yes.
Once the right is vested, it
Yes,
cannot be
it cannot be
divested.
divested.
This is what you want to
Yes,
say.
yes. Why should I repeat when your lordship knows it?
She was widow. She was widow. The woman's widow's right to a property was limited. Right. Before 1956, it was limited. By virtue of 14(1), the she had limited right merge into absolute right. Once the absolute right যদি vesting to remarriage করে দিলে, it is immaterial. Once the property has vested, the right has vested, it cannot be divested. মজার গল্প পেজ 15 এ আসুন, এখানে in his reply argument এখানে
In his reply, the appellant plaintiff submitted that onus of proof shifted upon the defendant to show that Lokimoni alias Lokmi Priya married Kutirun Sen after commencement of Hindu Succession Act 1956. From deposition of date order 1, it is proved that Lokimoni alias Lokmi Priya married with Kutirun Sen in the year 1947.
How can it be? আর ওর হাজবেন্ড বলেছে
1951,
তবে
died on 1951. In the year
জিজ্ঞেস
1951.
করলাম, তখন তো জীবিত ছিল।
Marriage before
Husband, তখন তো ম্যারেজ ইজ ভয়েড।
marriage is void.
যদি সাবসিস্টিং যদি হাজবেন্ড থেকে না কিন্তু ভয়েড হতো না, তাহলে তখন না হাজবেন্ড মেল ক্যান ম্যারি মোর দ্যান
one woman.
whether the woman can marry more than two.
No. Never.
Huh? Yes. লোক বলে দিয়েছে my lord, ground, my lord, কোর্টে যেটা করেছি দিয়েছেন
The appeal shall be heard on the following substantial question of law.
My lord, the senior counsel Honorable Chatterjee advocate his legs are busy on of the appellant. We are the appellant.
On the appellant side, I thought that you are for the respondent.
No, my lord. Senior advocate Honorable.
You are.
He is there. I will say, sir.
Who is the advocate in the court?
কি করেছিস?
Lord, the plaintiff, Lord, is the appellant before your lordship. Interesting question. Lord, the plaintiff is the appellant before your lordship. Lord, a suit for declaration and cancellation of certain Lord, two deeds to be Lord, void. But the property is situated at Madhu.
Take your seat for a minute. Let us hurriedly go through the impute order. Where is the?
My lord. ঠিক আছে ঠিক আছে Strategy was leading.
You are a plaintiff.
Yes.
Evening, my lord.
Oh, this was dismissed for default.
Yes, ma'am.
Then at order 41 stage,
Yes, my lord.
if the matter is wrongly listed under the heading order 41, rule 11 of the Code of Civil Procedure, instead of listing under the headings application, let this matter be transposed under the heading of application. You are bold enough to argue this. Still your matter is dismissed for default. You do not realize what is the consequence whereof.
May I say one thing, my lord? May I say one thing, my lord? Instead of delaying this, my lord, the application which has been filed under section 5 served upon me, I find it is filed within time, 30 days. So, my lord, I will not really oppose the application under section.
Restoration application, you are saying section 5.
The restoration application within time, within 30 days.
No.
So,
Have you seen the tenor of the argument or submission? What we can do? We were discussing this. Yes, sir, we are accepting.
Lordship, Mr. Devanik Banerjee is appearing on behalf of the appellant, Lordship. Unfortunately, there has been a bereavement in his family. Lordship, for this reason, praying for a week's accommodation, Lordship.
Not this week.
Your Lordship, I appear on behalf of the appellant. My appeal is still at the admission stage. I am being led by Mr. Deepan Kumar Sarkar. I am being led by Mr. Deepan Kumar Sarkar in this matter. I am seeking for a not today.
Why, madam, you do it. You are the advocate on record.
I'm the advocate on record.
So do it.
Your Lordship,
Just wait. Let the file come. Madam, this is out of time. Have you served? 61 days delay.
we haven't served, Your Lordship. We have filed a Section 5 application.
It appears from the report of the staff reporter that the instant appeal is filed beyond the statutory period of limitation. How appeal lies to her, to the High Court. Appeal would not lie to the High Court. How it will lie to the High Court in view of section 21 of the Bengal, Agra and Assam Civil Codes Act. Has to be filed before the district judge. Have you read that act, provision of the act? Are you aware?
No, Your Lordship.
Bengal.
Bangla, Bihar,
Agra, Assam. Civil Codes Act. Bengal, Agra and Assam civil courts hai. No, it will not lie here. Here, have to go there. File the photocopy, দিয়ে দিও। ওখানে লিখে দাও ACO, returned by the ACO. Next.
Lord, I'm led by Mr. Shoktinath Mukherjee in this matter, Lord. Lord, he is not, Lord, online now.
But I am for the respond number 1
Any
to 4.
day, Lord, next week, Lord, Mr. Mukherjee will be there.
Indulgence. Section 21 says that the suit value should not exceed 5,000 rupees. In that case, it will go to.
Amended up to 60,000 rupees.
My suit value is of 61,000.
So it will read that up to 60,000 rupees before the civil judge junior division. Above 60,000 to 1,50,000, it will go to the civil judge senior division. So in that event, if it is within the 1,50,000, then any order which is passed, you have to challenge it before the district court. 21(1)(a) amended as amended now. Yes.
Much obliged, Your Lordship.
I'm for the appellant, my lord. The defects, my lord.
Defective. What are the defects, sir?
Instead of
My God. Instead of, it is against the decree.
my appeal, my partition, I prefer the partition shoot, my
It
lord.
should be first appeal.
My lord, it should be first appeal, my lord, instead of first miscellaneous.
47 rule 11 rejected.
At the argument stage, my application has been rejected for not submitting the
Lordship, we have
Let us see the defect first.
we have asked for a week's
Don't
recommendation.
worry. Oh, section 5 is there. Okay. Yes, have you, sir, we are directing the service of the application.
Lordship,
What is the difficulty? The matter will appear after 2 weeks.
grateful, Lordship.
It appears the matter, क्या तो तुमरा दाओ এটা order 41 है तो আসবে না। যে কন্ডোনেশন না হলে তুমি অ্যাপিলটা অ্যাডমিট করবে পুরি এফএমএ কি আছে যদি কন্ডোনেশন যদি রিজেক্ট হয় তখন
Waiting for the respondent.
What?
I'm appealing for the appellant. Sorry. Sorry. No, the defendant in a suit for partition blood is
What is the impugned order? Number 13.
My lord, impugned order, my lord, is
Impugned order.
number 13, dated 2nd of July 2024.
Take your seat for a while.
My lord. It's a copy legible, my lord. I have another copy, my lord.
No, I have.
Legible, my lord.
Who are the defendant number 1? Yes.
My lord, my submission before the trial court was that the my lord, respective parties are occupying my lord, areas as per their my lord, share, and they have also, the plaintiff has also constructed my lord, a house even covering more area than the share which is my lord, allotable as per his share. He is occupying my lord, his building is complete. I am also having my lord, a small portion where my lord, I have a structure. Between the my lord, two rooms, my lord, I wanted to make some construction without my lord, claiming any equity, my lord, subject to result of the suit. That has been not turned down.
Is already there is already a structure.
A structure, not two rooms are there. Between the two rooms, there is a courtyard. This courtyard I wanted to develop, leaving a passage.
This courtyard is meant for the access of these two rooms.
No. There is a passage beside that courtyard, my lord. That passage is left open. And my lord, there.
No, you are trying to make construction on the courtyard.
On the courtyard, yes.
That means the courtyard is used for an access to one room from another room.
From it, in the portion occupied, my occupied portion. My occupied portion. And his house is in the back side.
Oh, I understand. So it is only a courtyard.
On the courtyard.
Not on any other vacant land.
No, not on any other vacant land. Between the two rooms, the courtyard I'm trying to, and there's a passage through which he can go to his portion. But wait with the court, my lord, that I made the application before the, my lord, Panchayat for permission,
I
but
know,
that
but
was
you got the permission after the
after.
injunction is granted.
Yes.
That I've seen.
So that is not the court took it very seriously that you have made
But
construction without
application was made prior to.
application.
And the court has said that the remnants of the building materials were found because you have already
Yes,
stacked
it was stacked.
in anticipation that
In
the permission
anticipation,
would be
some,
granted.
my lord, this is the position.
The construction did not started.
No, the report says that he had started. That is not the finding of the.
How you can start the construction without the sanction or permission?
We made the application, my lord. It was not
And
processed.
thereafter you started.
Lord, it was.
Is there any
It was
deeming
at the
provision that
nascent.
within 1 month, if it is not, then it will be deemed that it is sanctioned?
No, deeming provision, Lord, in this case, possibly I cannot know. There is a provision in Panchayat Act, Lord, Gram Panchayat administration rule. There is.
So far as my memory goes, it is.
It is there, my lord.
So if the application is made 3 months or 4 months prior to this, then
possibly no, my lord. I cannot make out that case. I don't have the documents to, my lord, make out the case of deemed sanction. I cannot make out. So, my lord, if the report, my lord, report was not challenged. So, my lord, initial at nascent stage, my lord, construction was started.
Stage of construction.
But now it is not the build. Basically, there's nothing, my lord. Don't building materials are stacked. Maybe, my lord, a few foundation work was done. Oh, it's a, my lord, my bamboo structure is made, my lord, and for for a roof, my lord, casting, some, my lord, structures have been made.
Page 61.
But roof casting has not been done. This is the position. Page koto? There's some photographs, my lord.
61.
Page 61, my lord.
Shows.
My lord, may I come back with a short affidavit? Because I'm challenging the oral partition that they are saying that is not legally.
You constructed your house.
No, my lord, that was not a.
And you are happy.
That was an old construction, my lord, prior to partition suit file, my lord. It is not the new construction, and they have got a new.
Casting has been done.
That was done after, my lord, the sanction was granted.
How can you do it when the injunction is passed? What is this? The casting is 61.
কাস্টিং হয়নি এটা আগের এই কাস্টিংটা করেনি এখনো ইনস্ট্রাকশন
Lord, in fact, we have also taken out an application for contempt, my lord, because after the injunction order has been passed, there were even if there were constructions been carried out. That application is on record in the court below, my lord.
এই যে এটা করা খালি ওই নিচে কাগজ প্লাস্টিকটা লাগানো বলে এটা মনে হচ্ছে
না এখানে মনে হচ্ছে তুমি ইয়ে করেছো কিছু
না দেখছেন না এটাই তো এই তো খাঁচাটা এর মধ্যে তো ফেলবে
I am told not that this is not the wooden structure made. The cement was not poured for roof.
64
Let them show that I have made a new construction, my lord. It was the existing construction that was there, which I have inherited from my predecessor in interest.
I am saying
you are making a construction above the ground floor.
Some there and some new.
Roof of the ground floor and
some new, my lord. Your lordship will find
62.
62.
On the roof, you said between 2 rooms. That is what I am asking.
Well, there is also that is one, and there is also a new construction in between the house of two of the brothers. Well, there is a sanctioned building plan.
Is not mine. This is portion of Gobindo Shatra.
Blue. At page 62.
Blue is not my portion. I am told not that
what is coming up.
Confused.
This is not my portion. Not the other.
This is your portion.
The one beside that, my lord.
That is the new construction, my lord.
Yes, the one beside that.
And that is why, my lord, there is a sanctioned building.
There's a passage between the two houses.
Okay.
That passage remains, but in the, my lord, shutter over this, my lord, I am told that this is, my lord, the portion where some further construction over the courtyard is being made.
The special officer,
would your lordship not appoint somebody, my lord, to inspect? Yes, my lord, page 58 is not the plan made by me, my lord. If your lordship kindly see page 58 once, my lord.
My lord, if your lordship kindly permits me 1 minute, my lord, I will the oral, they are raising their construction by virtue of an oral partition. My lord, that oral partition does not have any legal sanctity in my humble submission. I will show it before your lordship. Because
You are taking advantage of section 14 of the.
no, my lord, no, my lord. The oral part, if your lordship kindly sees,
Sir, if you are a co-owner, if you have a right to raise construction, how can you prevent the
no,
other?
no, after the partition, my lord, let my learned friend says,
Joint property. I'm talking about no party.
my lord.
A co-owner can make a construction. He will prevent the other co-owners from.
No, my lord, let them say that I have raised construction. I have not, my lord.
Enjoyed your portion.
I have not raised my construction, my lord.
Equity, if is ultimately happens, they will
My
demand.
lord, I have not raised any construction.
Trial versus some.
My lord, I have the judgment. My lord, but my lord, I have not raised that construction. Lordship, kindly record that. My lord,
Where is the property?
my lord, it's in Hooghly. Shingur.
Hooghly.
You are appointing a special officer to go and make an inspection. Let us see what is there.
Position.
Hey. Party. Anybody who
Hooghly Chandanagar.
Hooghly Chandanagar ke hai?
দীপায়ন কুন্ডু দীপায়ন কুন্ডু
Yes.
সিঙ্গুরে I'm told Madhumita Papa Singh is from Singur.
She lives in how? What is
Shingur মানে এটা কিন্তু ভদ্রেশ্বর সিঙ্গুর বোধ এটা কিন্তু ওই
how
সিঙ্গুর না।
senior she is?
10 to 12 years, I'm told, my lord.
Where?
আমার কোনো সিঙ্গুর সেটা কিন্তু ওই সিঙ্গুর নয় আরবেশ্বর সিঙ্গুর নয় এটা ভদ্রেশ্বর হ্যাঁ
এটা কোথায়? মোল্লা সিমলা সিঙ্গুর।
হুগলি আচ্ছা ঠিক আছে
সিঙ্গুরটা হুগলিতে।
হ্যাঁ ওই শ্রীরামপুর শেরাপল্লী হুগলি যে কেউ আছে
Hello. At the time of hearing the instant appeal,
from that area.
আসছে বললো।
Are we giving a name of a, on consent we shall give a name? We are giving the name, my lord.
তাহলে আমাকে একটু ওনার কন্ট্যাক্ট নাম্বারটা দিয়ে দিন, আমি অ্যাডভোকেটকে ট্রায়াল করে দিয়ে দেবো।
আসলে আমরা কথা বলবো। একটু wait করুন।
My lord, in this matter, I am for the appellate, my lord. My lord, what happened in this matter? My lord was pleased on the last occasion. My lord was pleased to ask me that why this appeal is, how this appeal is maintainable, particularly after the judgment of the larger bench presided over my lord Justice Shomen Sen, which was passed in the month of May, September, my lord. My lord, thereafter, I tried to search out in my humble way, but only on the last week, one of my learned brother was pleased to hand a copy of the judgment to me. It is a 75 pages judgment. My lord, I ultimately may have to go from this court, or this appeal may not be maintainable ultimately. But may I come back after going
How
through
much time a lawyer requires to read a 75-page judgment?
Only
I really wonder sometimes
only
when
3
you
days.
say how much time a lawyer should generally
No, that is my mistake, my fault, my lord.
take to read a 75 pages judgment.
My lord. My lord is
And
absolutely
that is
correct.
not a reported judgment of 75
No, not
pages,
reported. That was the reason.
That means it will come around to say 35 pages of a report.
Yes. So if not reported, that's why it took time, my lord.
How much time does it take to read that judgment?
No,
How much time?
Oh.
What do you think?
No. I am sorry, my
A
lord.
reasonable man, he's a lawyer.
My lord, I should have.
Wait till the last week you received it.
Since it is not a reported, my lord.
You had a weekend, must be some weekdays. 2 days have elapsed. We are on Friday, the Wednesday of this week also. How much time you require to read that?
No, in that case, my lord, only 2 days. I will not be seeking for more.
2 days.
Only 2 days.
Will you be able?
My
Because the past antecedent is very bitter. Or will give you a further time to read it.
No, my lord.
No, take time.
No.
We are just directing this matter to go out of this.
No, my lord.
Just go and read.
No.
In your leisure time and then do it.
No, my lord.
Whenever you feel that you have read it perfectly.
No. I will only take 2 days, my lord. Not more than that.
Not today.
The previous matter, my lord, Miss Madhumita Pato, she resides in the area. We have shown the address. She resides in that area.
Go there, make an inspection.
Yes.
We have indicated what you are required to do. Submit the report on the next.
Witness. Witness.
তোমার নাম আর ফোন নাম্বারটা লিখে দিয়ে দাও।
কার্ড থেকে ফোন নাম্বারটা দিতে।
ফটো লিখে দাও, নাম আর ফোন নাম্বার।
Call the name.
Please, Lord.
And 81, I am appearing on behalf of
that matter, my lord.
I don't recollect.
The lordship said
After
heard.
Stepping down 3 stairs, flights.
Lordship said heard the matter when lordships were about to pass the order, and then lordship said that my lords will pass the order. My lord, suit filed on 12th of September, made ex parte on 24th of September.
Oh, this is that matter.
That matter.
Yes. Sorry. Peter. Come. Can't do this.
Can't be. Say. He's giving
Is astonished. No, we are astonished to find which in our opinion does not deserve Out of a supplementary.
My lord, I am appearing, my lord. Arising out of an executive order of injunction in a suit for partition, my lord.
Against ad interim or
Against
refusal?
against refusal of the
Refusal?
refusal. Last occasion, your lordship directed me to serve the copy upon the learned advocate.
Yes.
Sure, I'm appearing for respondent no 1 to 5.
You have appeared. We are directing this injunction application to be decided immediately.
My lord, there we are appearing before the law court.
Your objection.
Yes, my lord, we have filed a written objection, my lord.
You filed your rejoinder.
No, I have not filed.
Will you file it within a week?
Yes, my lord.
So we can direct the preponement and then disposal within a time frame.
4th April is the date fixed before the learned.
Preponement.
Court. Write the names.
Pursuant to the order, we respond. You are appearing for
Respondent no 1 to 5, my lord.
all respondents.
Yes, not all, my lord. Remaining are not appearing, my lord. They are only 1 and 1, 2, 3, 4, and 5, my lord. They are only contesting defendants, my lord, before the learned trial court.
That service is affected upon other defendants.
Yes, my lord.
They are not contesting.
No, they are not.
This should be recorded.
Yes.
Appearing, your worship, pursuant to the order, dated 17/12/2000.
Lordship. 83, Lordship, I appear for the appellant. There is a defect, Lordship. I have to put in the requisite court fee. 20 rupees deficit, Lordship. My
20 rupees only.
my mistake, Lordship. The records were not checked up.
Not appreciated at all.
I completely bow down. I have to shoulder the responsibility. And
20 rupees you will not.
Lordship, in fact, I was puzzled because the record was checked up and I was told that there is a 20 days delay and I was confused. How can there be a delay when I have filed within this period? Lordship, it is I have to shoulder this responsibility, Lordship. I'll do the and my learned brother had actually
deficit court
corrected me.
Extended by a week from date. List the matter on next Wednesday.
I'm deeply obliged, Lordship. My brother had actually indicated what has happened because I was confused. I asked him and he clarified the position to me. I'm grateful.
He's always helpful to the juniors.
He is been a brother ever since I've been in this court and a very dear one. Always. I'm deeply obliged. Here is.
My lord, I am appearing. My lord, I am appearing in this matter.
Yes.
My lord, this suit for partition, and we are the defendant. I filed this appeal against the order of injunction.
What is
My lord,
injunction?
injunction is, my lord, restraining me not to change the character and not construct. But the fact is, as per their, my lord, their plaint itself.
Serve the copy and come back.
My lord, plaint.
Serve the copy and come back. The appeal is formally admitted. Appellate is directed to serve the copy of the application for injunction. Application for injunction or stay. Application for stay upon the plaintiff respondent by speed force, as well as upon the learned advocate representing them in the trial court by hand, and shall file the affidavit of service on the returnability. Which court?
My lord, this is, my lord, Midnapur. And I'm giving the date.
So you go on the weekend and serve?
My lord, I said, sub weekend is. I said, send.
Go to
every weekend. I called my clerk.
Every weekend you go there.
No, my Midnapur, I do not go. 24 hours is my residence.
Returnable after 2 weeks.
Grateful.
Appear for the appellant petition in this matter.
Lordship, Mr. Rahbar is appearing in this matter for respondent, Your Lordship. Due to some personal difficulty, he had to leave the court, Your Lordship, 10 minutes prior. Kindly, if can be made any other day.
Difficulty, I cannot say anything.
10 minutes back he left. Grateful, Your Lordship.
Let me submit the affidavit of service, Your Lordship.
86, Your Lordship, on the last occasion, Your Lordship had inquired whether the respondent number 1 has stayed in or around Chitranjan Avenue. Lordship, have taken instructions when they had moved to Calcutta, Your Lordship, they were staying at Burlia House in Singhi Bagan, Your Lordship, and thereafter they've stayed there for some time. So, Your Lordship,
As you Lordship.
I knew it, that's why. On my personal.
Grateful.
I appeared for them. Have they not disclosed?
Lordship, I believe some family members of them, this is Kanta Devi Bole, Lordship, perhaps their uncle or someone else in the same family, Your Lordship.
I used to be their lawyer when I was there.
Most of the civil matters will then get released from Your Lordship's bench.
I'm just only praying for one indulgence, my lord. Will you the pressure of Your Lordship to direct?
Sign it within 5 minutes. Don't worry.
Grateful, Your Lordship.
I'm so grateful.
এক্ষুনি প্রথমে টাইপ করে আমাকে দিয়েও সই করে
আচ্ছা একটু রেখে দাও হ্যাঁ সব
So the plaintiff is the appellate because initially when there is direction for service, we are under impression that it has been heard. Then we move before the court having jurisdiction to hearing of the application. There the court was of the honorable court was of the opinion there is no formal law admission. So now my lord it is
what?
Initial. So this is an order rejecting my prayer for entry order injunction. Against that, the plaintiff is before your lordship.
What is this? Which is the order?
In the
Order
memo.
number 2.
Yes.
Sick performance suit.
Yes.
Rejected.
Rejected. On the ground, my lord, if your lordship can consider the last portion of the order, the plaintiff, in order to prove the privacy case, has filed some documents. I have carefully gone through the said documents. It is a suit admittedly petitions of the defendants who was the original owner of the suit property executed a will in favor of these defendants. And admittedly, a probate case is pending. The will is still pending. Until and unless probate is granted regarding the said will, the defendant should not be entitled to the suit property. In the above circumstances, the authority of the defendants to enter into memo in respect of the suit property is inconsistent. Considering the above, I do not find any privacy case. They are the beneficiary, they are the legal heirs. Even if my lord, they are the also executor. Can you consider whether the under the Indian Succession Act, whether the executor has the jurisdiction? They are the beneficiary defendant, two sons. I have annexed the will, which will appear.
MOU, this MOU was executed with the original owner.
No, these two processes.
Or the
Original owner.
Testator.
Testator.
And then he died. Then he filed for a suit for aesthetic performance against them.
Against them. Now, my lord, the will itself, my lord, page 72.
You can sue the executor.
Yes, they are the executor, page 72.
And they are trying to sell.
Yes.
So what do you say?
But yes, time for filing the objections.
That court for that. It is an ex parte adjudication. You had no right now. Then you'll have to go to the trial. Since a valuable right has accrued, that's why we want.
They have accepted the money. Not only that, the person who's the president has accepted the money.
Well, Rajab, submitting this about this acceptance of the money. If they affidavit filing that we deposit the checks or the amount was credited from their account, we never deposit the checks. We never deposit the anything.
Was it in cash?
2 lakh was encashed out of, and 25 lakhs check was with them. 2 lakh already been encashed.
What is the MOU?
MOU is lordship will find. That is a pay.
Tell me what is the nature of the MOU?
It is a construction, making development along with transfer of the property.
My lord, I am folded and prayer. Give me 2 or 3 days to filing the objection upon this.
Then you have to go to the trial court and contest.
So they are already in trial court. Trial court, the matter is pending. So if,
Obviously, otherwise how
the,
how
and
the appeal will
on
will
last
come
date, the
before
court
us?
was
If it is
on-
not pending, then how appeal will come
once
to us?
last date, the court was not there. So that's why we cannot file the written statement.
Why?
So actually in this matter,
And in the department, not necessarily the court has to be
in
there.
this matter, my learned junior also taken the adjournment on my ground. For the same case on the adjournment was taken
Come
over there.
ready. Anything you have to come ready and argue on Friday.
I'm grateful, man.
Argue on Friday.
Friday.
Yes.
না না ফ্রাইডে
এটা ছিল এই শেষ করে দাও 88
My lord, I am appealing for the appellant.
I'm for the respondent.
Oh, same matter.
Yeah.
No.
It is the same party. Same
No. This is FMAT number, my lord. FMA number now, my lord.
This.
Demand. Order 41. Trial court dismissed the suit. Appeal court reversed the finding and remanded the matter. Yes. The appeal court is of the opinion the Solenama degree though was not challenged, but it appears that Solenama degree was there. Our case is that the Solenama degree, if it is at all there, between the persons who has no title over the property, if any title is conferred to the other person, then it requires registration.
But there is a delay.
No, my lord, now it is all allowed.
15 days.
Delay condoned, my lord, 30th August 2024. 30th August 2024, my lord, the delay was condoned. Subject question, my lord.
Oh.
But
yes, come on the next.
On Friday.
Rise by that in the story action number 92, your lordship generally takes up on Wednesday hearing.
Friday, my lord.
I was going to tell you, lordship, not to take up next Wednesday, my lord, because I would be out of station. Hearing.
We will fix the date for hearing matter.
Oh, now you are no lordship is not. If it is on next Wednesday, my lord, I will pay for it.
Because there are certain reserved judgments we have to clear out.
So the order 40 will take it up Friday.
We'll take up some and then we'll take Friday. ওটা দিয়ে দাও দুটো এসে গেছে